put money in trials. There has been also improvement in trials of women and children, and training for women judges and other judges who are interested in under our umbrella association, so that trials are gender responsive, especially in cases of sexual and gender-based violence, which form the bulk of our trials. There have been improvements in the ODPP as well, general review and management. Knowledge prosecutors are more readily, and then there's routine training. We use anatomical dolls. I don't know whether you use them now here. The prosecutors use them a lot during trials of children, and really this has helped in making these children feel at home and eased the trials. There are innovations at the bar. They have a pro bono scheme under the Uganda Law Society. 1,500 lawyers are available once a year to provide pro bono at Pro Bono Day. We have a pro bono app, duty counsel at prison and police. And by next year, pro bono will be compulsory. CSOs have also come in to help us with improving on the rights. They offer many services. Sometimes they come to court. They offer tracer services for missing or police files. You know, that's a big problem. And then legal aid. And there's a student practice program which has put a lot of emphasis on juvenile justice. There are also innovations in police. You can quickly look at those. They are now more result-oriented, and they allow the prosecution to lead their investigations, which has been quite useful. We are trying to build mini laboratories around the country because that would improve on investigations. No, the way forward, of course, we need to put funding into judiciaries, and more efficient and well-funded courts will mean more expeditious trials. And of course, the judicial officers need to be trained, and there must be a general consensus on the limits to conclude investigations, pre-trial, and trial procedures is very imperative. Of course, we need some legislative reform and positive policy, and eventually specialized courts. And there's a discussion in Uganda now to have a specialized court on sexual and gender-based violence. I know there are such courts which are very vibrant in South Africa. Those are the few recommendations and the way forward. Thank you very much.
Thank you very much, my Lord. You know, how to stop a judge is a problem, so I have to tread carefully. But my Lord actually tried to complete within the 15 minutes, extra 3 minutes. So let's give her a round of applause for that. We want to thank you for your presentation. She started by highlighting the legal and constitutional basis of the right to speedy trial, taking us through international instruments, domestic constitutions of African countries, and she examined the impediments. Of course, some of those impediments are also things we are definitely familiar with in our jurisdictions. And then she examined various interventions, case backlog committee, case load management committee, and some of the interventions that she examined, including the one on linked intervention. Some of these interventions really tell us that, yes, we need funding, but there are a lot of interventions we can undertake even without funding. And we could see that in their experience. And then also she looked at interventions by the bar, interventions by the police, and then she ended up making recommendations. I think we should give my Lord another round of applause. Thank you very much, ma'am. So we will move on rapidly to, we have heard from a judge. Now we want to hear from a former prosecutor who is now a defense counsel, Advocate Jean Busso Mutangana, Senior Advocate of Rwanda. He will be making a presentation on the role of prosecutors and defense attorneys in ensuring speedy trial. The floor is yours, sir.
First of all, I would like to thank everyone, especially for inviting me to come to speak to you today. Honorable Justices, my Lordships, Professors, all protocols observed. I'll be discussing about speedy trials and the role of two parties, advocates and prosecutors. However, it's very important also to investigate or question the role of other parties in the entire process of a speedy trial. Because in my view, my own experience, I believe that even investigators, police, or call it other investigation bureaus that commence preliminary investigations have got a very big role to play in ensuring that a speedy trial will be achieved. Prosecutors have a very active role. Advocates, of course, sometimes we say their hands are tied, but it's not. Some advocates also have a role to play. Also, look at the courts. What is the role of the judges and courts handling these matters? And how are we going to achieve speedy trials? So the four levels really are very important to investigate and to give a position, but I'll be focusing myself on the two, especially, while touching other areas as well. Sorry for my fonts. I try to make sure I highlight so that I don't read everything. I just want to focus on those ones which are highlighted. First of all, there are distinct roles to play in order to achieve a trial without undue delay. So these are distinctive roles played by distinctive parties. So it's not something that just comes up when the whole matter comes to court. We need to understand the role that starts with the entire process of a criminal justice or criminal investigation. So when we are talking about a reasonable time, it should be reasonable because parties have played a role. It cannot be reasonable just because an advocate has come to court to defend the accused persons. We need to ask ourselves, first of all, do we need to detain persons when there are no serious grounds to do so? Do we need to detain, police and prosecutors? Do we need to detain suspects without a prima facie case? We have seen many cases where suspects are detained, released, and re-detained, even for same facts. So really, if you're talking about a speedy trial, we need to be very practical in respecting the law, because when you are expecting a judgment court from a judge that comes within a reasonable time, what is our role? So I believe that we need to avoid public outcry and questioning the legitimacy of the institutions when it comes to detaining, because everyone has a right to freedom. This is fundamentally accepted in international law and regional domestic procedures of the laws. Because unreasonable delay of a trial is a human rights violation. When the public starts to question their own institutions, it becomes a very serious issue. And you have people writing in the media and everywhere, and other people do research on that. So we need to be respectful of the law as law enforcement. The prosecutors are law enforcement. They are investigators. In my country, investigators fall under the supervision of the prosecutors. We have what we call Rwanda Investigation Bureau. I believe it's like CID, Criminal Investigation Department in countries, police, because prosecutors do not commence investigations. It's Rwanda Investigation Bureau that commences investigations and submits the whole matter to the prosecutors, and prosecutors do the secondary investigations and submit the matter to the courts, to the competent courts. So we need to see how each level respects its own responsibilities. This thing is a little bit maybe to now. All we know that a right to fair trial encompasses speedy trial matter, and I've been talking about it. We are looking at safeguarding people's rights from illegitimate unnecessary delays. As we continue to exercise our rights with our people that we are defending, that we are prosecuting, that we are judging, we need to look at detention, first of all, as an exception to the entire principle. We cannot defend these people that we prosecute, that we investigate, our brothers, our sisters, our citizens, while we are looking at detention as a principle rather than being an exception. I think we need to see this, both prosecutors and judges. And when we deliver the entire substantive case to the judges to look at, I believe judges also have to do this. Yesterday I was talking about inspectorate departments in Rwanda, just to share experiences with you. We have the inspectorate department of the prosecution and that of the judiciary. It does not interfere with the daily work of prosecutors and judges. However, it checks and balances their work and looks at the procedures and questions, because we believe in accountability. Wherever you are, of course, you must be exercising independence, but if your independence is going to go beyond the reasonable independence in your work, especially as an investigator, then it raises a number of questions. I have to use mine because it's not changing there. So, I want to say the role of prosecutors specifically, starting with looking at the few resources that we have in our respective countries. We look at few lawyers, few prosecutors, even human resource and logistic resources. Few lawyers, few prosecutors, few judges, few judicial personnel. So in countries like mine, where we even had genocide taking place 28 years ago, in a country where, a poor country first of all, having a genocide taking place, and then you even have prosecutors and defense lawyers and judges themselves having committed genocide, having fled the country, and they are fugitives. And the country, I remember they told us that in Rwanda 1994 we had only 40 lawyers, 40 advocates in the bar who are active. It was not until many years that people had to go to university and graduate the law schools and then start working in the judicial system of our country. So think about such a situation, and when you think about detention as the first priority, then in my view, we have to think about freedom if we have to achieve speedy trials, because you cannot have hundreds of thousands of people in prison who have committed serious crimes like genocide, and you expect a speedy trial when the investigators and prosecutors and defense lawyers themselves are not even there. It would be a challenge. So prosecutors need to design plans as their role, and in those plans they need to be very operational in what they are doing. And by doing this, they have to do high quality evidence. I have it on slide, but I don't think it's actually coming on system. So what I'm saying is that prosecutors' role they have to have a plan in what they are doing, in investigating the crime. Because it's a professional requirement. You don't merely seek conviction because you're a prosecutor, but you only need to have the quality evidence of what you produce. Because once the evidence is of a high quality, it is going to be very important for the judge to understand it, and it is going to be even very important for the prosecutors to defend their evidence in court. So in my view, it's very, very important to have a plan. We spoke about pre-bargaining. Professor Dr. Bello gave me the pre-bargaining book which he has authored, which is very, very important. A few days ago in Rwanda, we started the campaign asking suspects and detainees to enter the plea bargain process, which is provided by our criminal procedures law. It is still new in my country, not really new because it came into our criminal procedure code in 2019, only 6 years ago. So people don't even understand it. But it is a process where they enter into that bargain with the prosecutors, and the agreement made will be presented before the judge, and the judge will decide on that matter. One of the advantages is to have a provisional release for the suspect, and it can be entered into on any crime. So this is also one of the key strategies that prosecutors have to actually go around and speaking to their suspects about it, because they may not be aware of it. So high quality evidence is very important. Quality of the investigation is very important. this will help in preventing backlogs. We had backlogs in Rwanda because we had over 100,000 detainees between 1994 and 1997 who had committed genocide. And if you think about a speedy trial in such a situation where even the law enforcement themselves, some of them were even suspects, with few resources and few even human personnel, it is a very big challenge. So that's why backlogs has to be avoided by all means, by both prosecutors and defense lawyers. Because even, we are talking about prosecutors now, but even defense lawyers have to play their key role. So, but for prosecutors, for the indictments they send to court, they must be of high quality. So the operational plans are very, very important. They have to assess their cases to avoid unnecessary delays, and therefore provisional detention should be an exception, unless they are very, very serious grounds. Another issue, when we talked about plea bargain, I remember I was telling my colleague, Dr. Dennis Bikesha, the Dean of Law School, of a case that I won this morning. I applied for a plea bargain. Prosecution is not really supposed to accept my request. It was not accepted. They decided to do an accelerated process. In our laws, we have what we call accelerated procedure. So once the suspect is confessing and pleading guilty, you don't have to wait for 3, 5, 6 months to go for a substantive trial. The law requires the prosecutor to present such a suspect who has entered a plea to be tried within 15 days. And one of the advantages of that is that actually you are accepting to pay back what you have taken fraudulently, depending on the crime. You have confessed and pleaded guilty. So what is the need of going to prison? The law provides an alternative of fines and a suspended sentence. And I got a suspended sentence with my client. And he's happy, he's not going to prison. So that is one example of a plea bargain, because it was not a plea bargain, it was a confession. But the advantage of confessing before the judge is also a very huge advantage, because judges in Rwanda are not obliged to send you to prison when you have confessed. They can give conditions for you to report or pay whatever you have taken or something like that. So this is also a very, very important aspect that we can share as experiences. So defense counsels, forward to the defense counsels, please. For defense counsel, for defense lawyers, to role of defense counsel, go behind a little bit. Yeah, we have delays generally brought by advocates. Practically, you look at advocates in court, some of them seek adjournments, seek stays, submit medical leave certificates which are not even justified. Others, we have a system called Integrated Electronic Case Management System in Rwanda, where all systems meet. So you don't have to collect files or boxes of files to court. Everything is accessed online. Even if I had cases this week, I have submitted my ticket that I'm not around and my invitation, and all my cases will be adjourned because there is a justification. So, but you have advocates who are going to be absent for no reason, or just go into the interest of their clients, which are not justified, to seek adjournments and stays. This is something that we need to avoid. And so it has to be reasonable, it has to be appropriate, and it has to be submitted and explained for the court. If different countries have this system, we have a system, I believe you have the same system in countries where lawyers, judges, prosecutors, investigators meet, and you submit all the evidence to the system, and everyone, is disclosure, generally disclosure in the system. So you access everything from the other party before you come to court. So I want to say that advocates really have a big role to play. They are officers of court. There has to be an aspiration of a speedy trial. So they shouldn't be the ones employing delaying tactics generally, because we have seen this and we should discourage it. And another thing is, sometimes advocates in my country, there has to be some fines sometimes put in place in different. In my country, advocates are fined on a regular basis. The law provides for fines, and it's actually, I think the minimum is around 200,000 Rwandan francs, which is around $200 for any unusual, unnecessary delay. And if this is applied in different jurisdictions. However, advocates continue to delay cases, and sometimes they don't maybe find this money to be a lot. But in my view, why do you need to be fined? Because this goes on record that you've been fined. You don't have to have such a record. So there are a number of factors that may lead to that delay. I put in some cases of the ICTR, the case of Ahimana, and the media case, that's the Naimana case, where the judges said we have to look at the length of the delay, the reasons that has caused the delay, why the delay has come. So generally the delay is not always justified, but sometimes it may be justified to have a delay. But the delay has to be generally justified. So briefly, we need legal and judicial reforms in our systems that address these issues. Rwanda has experienced necessitated legal and judicial reforms due to the problems of high magnitude that we faced. And we have been undergoing the same reforms since 2001. Currently, I would say Rwanda is not even entirely civil law system. It is a hybrid. We have common law practices that we never had before, plea bargaining, cross-examination. We never had this in our legal system. But now, as you know, civil law judges are very active judges. Even judges in Rwanda can conduct investigations. They can even go to the field, figure out whoever they need to speak to or visit the scene of crime themselves. They are allowed to do it. It is very rare, but the law allows them to do what they call itinerary of judges, if I may do French. So it is also another important thing for them to cross-check whatever might have been left behind the other two levels. Hence, I mean the prosecutors and the police. So these reforms are very important, must be continuous, taking place in different jurisdictions. Reforms can never stop. Every time we learn, every time we need to adjust and look at what we need to do as defense lawyers, as prosecutors, and other institutions. So to make it quicker, I also wanted to say that there has to be compensation. As you know, compensation, speedy trials do not only guarantee citizens trust towards their judicial institutions, but will also avoid illegal detentions and others. However, there has to be a right to compensation to the victims, which is also provided by the African ICCPR, International Covenant on Civil and Political Rights, which many countries have subscribed to, especially in. So it is important for advocates and prosecutors to always invoke constitutional provisions in their defense. Sometimes you find advocates don't even invoke them. They go on procedural law, whereas the supreme law of the land, which should be guiding the courts and everyone in the court, is forgotten. And we always call upon advocates to make sure that whenever they're making arguments, they mention all about this. So I come to an end of my presentation by talking about equality of arms. Equality of arms is a very important aspect, but even equality of resources. Because you find defense lawyers are not in a better position as prosecutors. Prosecutors are government officials. They have resources available provided by the government, whereas bar associations in our country, some of them, sorry to say so, because defense lawyers have to cater for themselves, they have to even defend their clients, visit them in prison where they're incarcerated, prepare defense submissions, submit them to court, they need transport, they need everything. So it's very important for bar associations to support them, make sure they deliver through the experience. Another thing we have private prosecution in our country, which is also another advantage. So when the prosecutor has not submitted the matter to court, an individual or a victim can submit the matter to court for private prosecution, but the burden of proof lie on you. And this is also being helpful to speed up trials as well. So finally, my recommendations are only three. One is there has to be appropriate remedies and sanctions in the event suspects' rights to trial within a reasonable time is intendedly denied, but it has to be intendedly denied. There are other delays that are not caused by any party. Some of them come from even the judges, from courts, because they believe nobody is going to question them. They have their independence, so they can come up with their own reasons that they were attending a training for 2 weeks, and your client is in prison. Those 2 weeks count a lot. So appropriate remedies are very important. Second is time limits should be set and respected, in which defenders must be brought to trial or granted bail immediately. We have to believe in bail. What's wrong with it? Because what do you benefit when someone is languishing in prisons for 6, 10 months or even 2 years before a substantive trial is conducted? Third one is that courts of law also have their role to play, not only prosecutors and investigators, prosecutors, but courts of law also have a role to play, because we have seen that courts of law, despite backlogs that they have, but even ordinary cases delay for no reason. And we always have to wait for the court registrar, fix a date, communicate it to the defense. Prosecutors don't mind a lot. When they have submitted the matter to court, someone is in prison, their job is done. But you have a role to defend your client, and the court has a role to communicate a nearest date possible. So I would say that in conclusion, this is my recommendation. I have my slides there. I'll share them. Without taking much time, I want to thank you, Mr. Chair, for the time given to me, and I'll be happy to respond in the exchange of the discussions. Thank you very much.
Thank you very much, Advocate Jane Bosco Mutungana, Senior Advocate Rwanda, taking us through the role of the prosecutor and defense attorneys in ensuring speedy trial. And he has taken us through some of the challenges that they had in Rwanda following the genocide, which led to a situation in which they had only 40 lawyers. And you can imagine the backlog of cases that they will have had to deal with. And then he looked at some of the things that prosecutors need to do to ensure that cases don't stall, ensuring the quality of investigation, ensuring the quality of evidence, so that when matters are presented in court, those things don't, lead to delays. And then he also, explained the role of plea bargains in ensuring speedy trial. And he also went ahead to tell us about guilty pleas that are not plea bargain based, which also are backed by appropriate non-custodial measures, which encourages defendants to plead guilty. And once they plead guilty, they know that at least for some offenses, they will not end up in jail. And then he also focused on the role of defense counsel, whereby defense counsel unnecessarily cause delays. We've also had that challenge in Nigeria, and some of the reforms have tried to deal with that. And then he mentioned the issue of punitive fines, which they've adopted for advocates delaying trial. Some of our courts here have also been adopted that. And he ended up with making some recommendations, providing appropriate remedies where there is a breach of the right to speedy trial, setting time limits for trials, which we have tried to do in Nigeria with some level of success. So, Senior Advocate Mutungana, we thank you very much for your presentation. So quickly, we'll move on to one of our online presenters. I understand Rita Itim, Senior Magistrate, is waiting in the wings to make a presentation online from Zoom from Cross River. Is she ready to make a presentation? Senior Magistrate Rita Itim. We also have another online presenter, Taiwo Abiodu Oni. If he's ready, we can take any of the online presenters that are ready so that we avoid. Okay. Rita Itim appears to be around. So you can unmute. She's making a presentation on justice delayed is justice denied. Delay in trials as a clog on the wheels of justice. So you have the floor, madam. You have 15 minutes, please. 15 minutes. Please check that you have unmuted. We can't seem to hear you. Please, madam, make sure you have unmuted.
Analyst, Mr. Chairman, I'm super elated to be presenting my paper at the maiden edition of this conference.
It looks as if we have Mr. Taiwo Abiodun Oni
to African criminal jurisprudence.
Okay,
I'm
let's just listen to
it. And I've titled my paper Smarter Courts, Smarter Justice, Adopting Artificial Intelligence to Nigerian Judicial System.
Sorry, Mr. Abiodun,
now,
just to let you know that
the fact.
I'm not even sure you can hear me. Yes, just to let you know that you have 15 minutes, please. Thank you.
That technology has changed the dynamic in the way we communicate, transact businesses, move from one place to another, and even in the dispensation of our legal services. However, same cannot be said about the court system, especially in the Nigerian state. There is skepticism as to the full adoption of technology, not to talk about artificial intelligence, to the court processes. However, before I go further into the presentation, I think it's circumspect that I give meaning to the term artificial intelligence, or to the concept of meaning to the term artificial intelligence, or to the concept of artificial intelligence. Now, the most acceptable definition of artificial intelligence, which I think anyone should resonate with, is the one preferred by John McCarthy, the person who is credited to have coined the term artificial intelligence. It defined artificial intelligence as a device or tool that imitates human processes or human behavior, so much so that it makes it even better. From this definition, we can see that three things are established. The first is that artificial intelligence is a tool or device or software. The second is that artificial intelligence is an imitation, a mere mimicry. And the third is that artificial intelligence makes human processes even better, or processes created by humans even better. I think these three things are very important in demystifying the fact that artificial intelligence is some supernatural alienic force that comes onto the surface of the earth to displace humans or to take human jobs. So one would ask, what is the link between artificial intelligence and the courts? You and I would agree that the courts, especially the Nigerian courts, are slow. They need to be fairer, they can be better. On average, a judge in northern Nigeria has 15 cases on his docket, and in southern Nigeria, especially in Ibadan, in Oyo State and in Lagos, have about 30 cases per day on their dockets. It is human impossible, to maximally and efficiently dispense justice in all of these cases, because the demand of these cases will wear on the judges. But artificial intelligence is not human. It does not need glucose level. It does not tire. All it needs is All it needs is to be updated from time to time. And that is the nexus between the courts and artificial intelligence. It makes the court processes fairer, faster, even better. Now, what are the uses of artificial intelligence to the courts or to the judicial system? The first one I would say is to organize information. We know, especially an appeal, the volumes of document that needs to be produced for an appeal, or for even a criminal trial, from witness statements to writs and all of that. But artificial intelligence can help sift through this information within record time to bring out only the important parts of this information and present them before the courts. That's one of the uses of artificial intelligence. Another use of artificial intelligence is an advisory role. Artificial intelligence can play an advisory role such that it advises the litigants, the legal practitioners, and even the courts on the best route or the best form of action to go in any matter before the courts. And we have seen this in British Columbia and Canada through the use of Civil Resolution Tribunal, which is an artificial intelligence tool used to dispense automated processes in real estate businesses. Another artificial intelligence used to court system is to ensure speed and to reduce stenography. Now, a judge in all of those 30 cases, all of those 15 cases, has to write by hand all of the things that are said by the witnesses, the litigants, the legal practitioners, and even himself. And we know that would take time. Courts have to start by 9, court sits at 9, and sometimes courts closing at 4 p.m. in the evening. When does the judge have time to do all other court businesses, such as reading, researching, and even writing down judgments. Now, we've seen that in 2021, there was an artificial intelligence tool that was launched by the Attorney General of the Federation, the person of Abubakar Malami, the QSoft de novo system, which introduced a feature, a very important feature, which would increase the speed and completely obliterate stenography in Nigerian courts. This feature is called the speech-to-text feature. Now, a special microphone is produced where, as witnesses, litigants, legal practitioners, and judges are speaking, all of these conversations are transcribed in real time to text, which can be printable and produced and available to the parties, to the litigants, and to the judge after each and every court proceeding. That has been said to reduce or have the potential of reducing the time spent in court by 78% and increasing efficiency by the same percentage. Another use of artificial intelligence in the court system is by predicting justice. Now, there is an aphorism, a legal aphorism, or legal maxim as you can call it, that justice should be done and not always seem to be done. But another use of artificial intelligence is a predictive justice tool. There is this mystery that the court system is shrouded in, where everyone at the sight of Lady Justice is in shivers. However, justice doesn't have to be that way. Justice can be predicted. It can be seen even before the case is brought before the courts. And through the use of artificial intelligence, we can achieve predictive justice. There is a tool currently in the use in the United States called the Predicting SCOTUS, that's Predicting Supreme Court of the United States, where through the use of a coding of judges' political preference, judges' historical, judgmental history, and behavioral analysis, they are able to decipher what the possibility of a judge's decision be after every trial. That way, litigants know whether or not to invest their money into going to court or to seek other alternative dispute resolution mechanisms. So, artificial intelligence can help better the court system by achieving predictive justice. This will not only decongest the court, it will create a more transparent court, a court that you and I, the litigants and judge, would agree with. Another feature or another use of artificial intelligence to court system is in the decision of bail or recidivism. Now we know, especially in the Nigerian court, that bails are usually at the discretion of the judges, especially in serious offenses. Sometimes judges may have a hard time in deciding whether to grant bail to a particular witness, to a particular defender, criminal defendant, probably because it's a flight risk or probably because he has a criminal past. But with the use of artificial intelligence, a judge does not need to rack his brain in deciding whether a client or a criminal defendant is a flight risk or whether it will not appear before the court at the next adjourned date. There is currently an artificial intelligence tool that is used in the United States called the Correctional Offender Management Profiling and Alternative Sanctions System. It's called the COMPASS. I'll take it again. The Correctional Offender Management Profiling and Alternative Sanctions System. It's called the COMPASS system. It's an artificial intelligence tool used by the police in the United States that helps to tell whether to release a suspect on bail, on administrative bail, whether it goes into the system, the centralized system, to see the criminal past or criminal history of a suspect, and to decide whether a client or defendant is a flight risk. And through this decision, it becomes an open process. Bail adjudication and decision on recidivism becomes an open process. However, we know that no process or no single system is perfect. Artificial intelligence is not without its faults. It's not without its disadvantages. And one of the pronounced disadvantages of artificial intelligence of adopting artificial intelligence to the court system is its ethical or fundamental rights considerations. Now we know that for artificial intelligence to function, personal information, organizational information, and even intricate details of cases have to be inputted into the system. And we know that for it to function, experts have to have access to this system. And so personal information of persons are available to third parties that are not necessarily agents of the courts. And so data privacy protection comes into play. We know that the European system have a very robust, the European system and probably the Nigerian system has a little bit of a robust framework for data protection, but this is not as comparable to the European system. In the European system, while artificial intelligence has been accepted as one of the ways to dispense justice, it has, however, created the European system has, however, created a caveat to the effect that judges or the courts must inform parties to the case or to a particular matter before it that an artificial intelligence tool which is accessible by third parties is being used by the courts as it is. Another issue is probably the fact that if artificial intelligence tool is used as a parameter for arriving at a decision, does it violate a person's right to fair hearing? Does it violate a person's right to dignity of human person? Does it mean that the person is being judged, the person's behavior is being judged by a machine or by some software? Or another disadvantage is the fact that while a judge may be able to impute some factors, emotional factors, into arriving at a particular decision, it may be impossible. It may not be. While it may not be impossible, such can be coded, but it may be to a minimal instance impossible for artificial intelligence to be able to gather all of the external variables and factors into arriving at a particular decision. Also, it is also possible that artificial intelligence may be seen as taking over or replacing judges, even though from the definition of McCarthy that I gave earlier, it can be said that artificial intelligence is only a complementary tool and not a supplementary tool to criminal justice administration. Now, there are some safeguards that can be put in place to making sure that artificial intelligence and traditional court system coexist or are complementary to each other to arrive at justice. Now, one of them is to make sure that the process of coding artificial intelligence keyword tools are explained in details to both the judge and to the defendants or the litigants before the court. This way, the parties are aware of all of the variables before the court that is used to arrive at a decision. Another is to guarantee by law and practice that judges can overrule the decision of AI. And this is to lend credence to the fact that artificial intelligence is only supposed to play a complementary tool and not a supplementary tool to the agreement. It's not in total agreement with an artificial intelligence assessment. The judge has an overriding power to follow either his own decision or that of the artificial intelligence assessment. Another is to make sure that side by side a judge gives his own independent decision. So while artificial intelligence is giving his own assessment, the judge also gives his own independent assessment of the trial, such that on appeal or in a case where a litigant feels aggrieved by decision, he appeals to a higher court, and the higher court can weigh the decision of the court, of the lower court judge, and artificial intelligence assessment decision, and see that which to follow. So while the Nigerian court is a long way away from adopting technology, or not to talk of artificial intelligence to the court, it is not impossible. We have seen with the adoption of the QSoft de novo system that artificial intelligence is a possibility. It would make the judicial system faster, fairer, transparent, better, and also increase efficiency in criminal justice administration, in the decision of bail, recidivism, and also help to decongest the court in its entirety. I will end with a statement. Which says, no force on it can stop I'll end with the words of Hugo Loris, where he said, "No force on earth can stop an idea whose time has come." I think it's the time of technology. I think it's the time of artificial intelligence. It's either we get with the times or we are left behind. I'll end with the words of Hugo Loris, where he said, "No force on earth can stop an idea whose time has come." I think it's the time of technology. I think it's the time of artificial intelligence. It's either we get with the times or we are left behind. Thank you very much.
Thank you very much. Thank you. Let's give Mr. Taiwo Abiodun Oni a big round of applause. Thank you very much. We thank God for artificial intelligence. You are about 10 or 11 hours drive away from here, but yet you have been able to actively participate in this conference. So we thank you for your presentation. You have highlighted, eloquently the uses of artificial intelligence, how it can help us to, organize information, how it can help us to speed up our trial processes, and so on and so forth. You also highlighted some of the challenges, and I don't think anybody here would disagree with you that it is an idea that its time has come, and we have to just find ways of living with it. The irony of it is that some of the issues that we raise in relation to funding, artificial intelligence can actually help us to address it. Why do you need a big court complex, you running on diesel, running on the facilities, when all the judges can take their motions, even, contested motions via Zoom? The judge is in the comfort of his house. He will not use up to 500 naira data. You are joining from Abuja, the other lawyer is joining from Kaduna. You are moving your motion. So all the costs, some of the costs that is, we are dealing with in administration of justice can actually be sidetracked using artificial intelligence. So I think it's an idea that we have to take more seriously. Thank you very much, Mr. Abiodun Oni. I believe that we are still waiting in the wings, Senior Magistrate Rita Itim from Cross River. If you are still around, we apologize.
Everyone.
Okay, sorry, we apologize for the initial.
Observed. I want to.
Okay. Yes, I was going to apologize for the initial mix-up, but you can go on, ma. Thank you.
First, to begin with, appreciating the Jewish Trust Center for Social Legal Research and Development for organizing this Maiden Regional Conference on Criminal Justice Administration with the theme Consolidating Reforms in Criminal Justice and its Administration, Best Practices. Without much ado, I will proceed to my paper proper. The hearing, if a matter is filed or a criminal matter is prosecuted before the court, anything that hinders the matter from being heard quickly will be referred to as a delay. What are the legal and institutional framework geared towards addressing the issues of delay? First, we have the Constitution of the Federal Republic of Nigeria, 1999. Section 36, sub 4 of the Constitution provides that whenever any person is charged with a criminal offense, he shall be entitled to fair hearing within a reasonable time. The Constitution does not define what fair hearing is. However, there are a plethora of cases. The Constitution does not define what reasonable time is. However, there are a plethora of cases wherein the term reasonable time has been defined. In the case of Ariori and Elemo, reasonable time was defined to mean a period of time in which the search for justice does not wear out the parties and their witnesses, and which is required to ensure that justice is not only done, but seen to have been done. Giving credence to this provision of the Constitution is the recently enacted Administration of Criminal Justice Act 2015, which was enacted repealing the Criminal Procedure Act and Criminal Procedure Code, which was applicable in Northern and Southern Nigeria, respectively. The Administration of Criminal Justice Act begins with its purpose of ensuring or promoting the efficient management of criminal justice institutions, as well as ensuring speedy trials in courts. There are several provisions in the Administration of Criminal Justice Act, which could be shortened as ACJA 2015, that are geared towards addressing the issues of delay in criminal trials. First, is the abolishment of stay of proceedings in criminal trials. Section 302 of ACJA outrightly prohibits bringing an application for stay of proceedings. What this means is that whenever a criminal matter is ongoing in court, no party can bring any application to stay the proceedings in order to appeal or pursue an appeal in a higher court. Secondly, the ACJA has also limited the number of adjournments. In Section 396 of ACJA, Section 396 of ACJA has provided that each party is only entitled to 5 adjournments each, and the adjournment period or days within the adjournment period shouldn't be more than 14 days. However, where each party exhausts its 5 adjournments and the matter is not yet concluded, they could apply for a further adjournment, wherein the court may only consider an adjournment that will not be more than 7 days. Section 290 of ACJA also centers on remand proceeding. Section 290 empowers the magistrate to play supervisory role over remand proceedings. This helps in putting an end to the issue of holding charge, wherein prisoners or defendants or persons suspected to have committed an offense are remanded in prison custody without proper arraignment in the appropriate court. So Section 292 supervises the remand proceedings from when application is brought till when the defendant is arraigned at the appropriate court. There is also payment and protection of witnesses, which is provided for under Section 251, 252, 253 of ACJA, and also Section 333 and also Section 232 of ACJA, which permits the masking of witnesses to enable them give evidence without fear of any risk that may be attached to the evidence they give in court. There is also Section ACJA also makes proof of evidence compulsory. In Section 346 and 376 of ACJA, it provides for what should accompany a charge or information that is filed either in a magistrate court or a high court. Section 315 and 3967 of ACJA also empowers a judge. Section 315 actually empowers a judge to deliver the judgment of another judge, a judge or a magistrate to deliver the judgment of another judge or magistrate, where the presiding judge is not able to deliver the judgment due to maybe ill health or some other circumstances. Secondly, Section 3967 empowers an elevated judge to go back to the High Court to conclude part-held matters, although this provision of ACJA, Section 396, sub 7 of ACJA, has been declared void or unconstitutional by the Supreme Court in the Ojus or Kalus case. There are also other concerns that the section has raised. It's also provided in ACJA that confessional statements be recorded in the presence of a legal practitioner or any other person elected by the defendant. Section 15 helps to do away with the issue of trial within trial, where such statements are being tendered in court, the defendant might want to raise objections centered on involuntary statements. By Section 315, where the legal practitioner is present, it helps to do away any force or duress in making such statements. Section 110 also provides for a period in which criminal trials must commence in court. Where a charge has been filed, the criminal trial is expected to commence at least within 30 days. Although it does not state when it should be concluded. However, the same Section 110 provides that where the case or the criminal trial is not concluded within a 180 days period, the presiding magistrate must give a report or send a report bordering on why the matter was not held or has not commenced within 30 days, or why it has not been concluded within 130 days. He must make a report and send to the Chief Justice of the state, who will review the report accordingly. What are the causes? Having been said, with these very commendable and laudable provisions, which is not even exhaustive, which has been provided for in the Administration of Criminal Justice Act, there are still matters, criminal matters in courts that are being plagued by delays, that are not being dispensed of with quickly. This brings us to the causes of these delays. What actually causes delays in our courts? First, we have the inadequate court facilities or personnel. This is not something new because most of us who work in courts in Nigeria, who work in courts or have connection either as judicial officers, litigants, or lawyers who appear in courts will know that the court system in Nigeria suffers very serious infrastructure problems and also personnel problems. Sometimes you go to courts and the clerks are not even enough. Even the personnel in courts, the judicial officers themselves are not even enough. You see a lot of judicial officers having cases being piled up. They sit from morning till evening and they are not able to decongest their course list. They have a lot of matters waiting. Sometimes adjournments might, as a result, sometimes adjournment might take weeks or even months from one period of adjournment to the other. There is also the problem of paucity of funds. These cuts across the various stakeholders in the justice sector, the Ministry of Justice, the judiciary, the prisons, and other prosecuting agencies. There is also the issue of poor remuneration and welfare packages. This particularly affects the people that are the stakeholders that are involved in the criminal justice sector, like the court officials or judicial officers, other supporting staff, prisons, police, the police, and others. You find out that there is always a complaint of not having enough resources to maybe move prisoners to court or even buy materials or equipment to be used in court. Where all these things are not, where the people working or the officers, the judicial officers, are not properly remunerated, it affects their input or their output, affects how it affects their output in court, which may lead to adjournment of matters. So when judicial officers and other workers are not properly remunerated, the zeal to work is not usually there. When they don't have cars or means of going to court, they might easily take adjournment or go to court only when it seems to be convenient for them. The issue of remuneration is something that must be taken seriously. There is also the issue of lack of willpower from the various stakeholders in the justice sector, the lack of willpower to do the right thing, the lack of willpower to put in their best to making sure that justice is done at the end of the day. There is also the issue of transfer of personnel. Judicial officers could be transferred from one jurisdiction to another. Even investigating police officers could also be transferred. And when it's time for them to give their evidence, there is a problem of mobility from where they are new posting to where they are to give their evidence, to the court where they are to give their evidence. There's also corrupt practices. Corruption is an issue, a general Nigeria problem. It's a social malady that's eaten into various sectors of the economy and has not spared the judiciary. So that's another issue that continues to contribute to the delays we experience in our courts. What can be done? I have tried to look at some other jurisdictions in comparing with some other jurisdictions like Rwanda and Netherlands. I have seen that there are some policies or reforms or reforms that could be adopted from these countries so that Nigeria could move a bit forward, a step a bit forward towards achieving speedy dispensation of justice in our criminal justice sector. I looked at Rwanda, being that Rwanda had suffered a genocide in 1994, but today they are ranked as one of the best in rule of law in sub-Saharan Africa. In short, the best in rule of law in sub-Saharan Africa. What did they do differently? They had a war, yes, but they did not just remain in the ruins. They did not just remain in the war or the effect of the war. They were able to get up and progressively build and reconstruct structures that were destroyed in the course of the war. And they also had the international support to build new courts that meet up with ICT standards. They were also able to create substitute courts or substitute judges to try matters. Like during the genocide, there was a Kaka court that was created to help try genocide-related cases that were that had lesser punishment to try these cases so as to reduce the backlog of cases that were waiting to be heard. They have also been able to create commercial courts, which makes commercial disputes go to a different court, and in helping to reduce the cases that are waiting for the regular court judges to handle. They have also other courts that are specifically directed at hearing genocide-related matters.
Your Honor, please permit
Also
me to interrupt you. You have about 5 minutes more. Thank you.
Rwanda, their judiciary
5 minutes.
is
I understand that recorded, so you can continue with the playing of the recorded presentation.
Can you hear me?
So you can just continue from playing where it stopped. I thought she was presenting live. I didn't know it was a pre-recorded version that was being played.
Financially autonomous, which makes it easier for them to regulate the finances of the judiciary and not rely or depend on the executives for funding. In Rwanda also, where a criminal trial has been held, at the conclusion of the trial, judgment is expected to be delivered within 30 days from hearing, or 3 days or 3 days when the defendant is in custody. Going forward to Netherlands, what have they done differently? I particularly picked interest with Netherlands because I've seen that over time or recently, they've been on the news for a country that has less prisoners. Their prison population is really low. And I tried to probe further to know why a country is almost turning its prisons to recreational centers and other facilities that are needed. While in Nigeria, our prisons are not even enough. In Nigeria, it is said that 68% of prisoners in the correctional facilities are awaiting trial. This is what delay causes. So what has Netherlands done differently that has reduced their prison population? In the course of my research, I noticed that one of the reasons why the prison population in Netherlands is very low is because their population generally is low. It's a country with only about 17 million people. So it can't really be compared to the population of Nigeria. And apart from their very small population, their attitude towards some societal and morally controversial issues such as prostitution, drugs, and euthanasia is kind of different. They don't see these things as offenses in Netherlands. These are things that ordinarily in Nigeria will amount to a criminal offense. So in Netherlands, they don't see it as an offense. So there's no need arresting somebody to stand trial for these offenses. And eventually there will be nobody going to prison on remand or to serve any jail sentence for contravening any of these laws. Apart from that, there are other things they have done differently that Nigeria could also adopt. In Netherlands, their prosecution service, which is the equivalent of a the Department of Public Prosecution in Nigeria, have enormous powers. They decide the matters to take to court. They know which that they can easily settle within the office, knowing that if such matters goes to court, maybe it was not properly investigated, it might end up being struck out on some technicalities. So they try to see how they can resolve some matters and know exactly which one should be taken to court to avoid unnecessary delays when the matter finally gets to court. The prosecution service also works very closely. There's a close union between the prosecution service and the investigators, because the prosecution service gives the investigators instructions on on what to look out for in their investigations. This helps in proving, because the prosecutors are the persons that have the knowledge of ingredients of each offenses. So they work closely with the investigators so that during their investigations, they are able to do a detailed investigation. So the appointment of substitute judges, laws like Rwanda, time spent, if he's convicted. In conclusion, having said that, in conclusion, what do we have to what is the present state of the criminal justice system in Nigeria? Having seen that the ACJA has provided is a very rich law with very commendable provisions, yet we still experience these delays in our courts. What have we not done properly? What this invariably means is that there is something missing. Nigeria must move from enacting laws to adopting policies that would aid in laws, just like what Rwanda has, that the judiciary should be granted financial autonomy, a register of experts and interpreters should be kept. There are times when matters are adjourned because there's nobody in court to interpret to either the defendants or the witnesses to interpret what is being said. So we must keep a register of interpreters and translators. Also, a register of experts is also needed. It's also, we also have to abolish the trial within trial. It slows down proceedings. Trial within trial has actually been abolished in Cross River State by a practice direction of 2018. A proper funding of other institutions in the criminal justice sector must be taken seriously. I've further recommended that specialized courts should also be created to help the regular courts in handling some cases. Like we know the period we find ourselves in Nigeria today is a period in which insecurity is ravaging the entire country. They could create courts like courts to try offenses like terrorism and internet-related crimes. I've also further recommended the amendment of ACJA to meet up with some concerns or questions that have been raised concerning certain provisions of the law since it was enacted in 2015. And finally, I have recommended the continuous training and retraining of the stakeholders in the criminal year. And here I am today in a conference geared towards criminal justice administration in Nigeria. It is really commendable. Nigeria must therefore move to ensure that all those involved in the criminal justice chain do all that is necessary within their power to ensure that when matters comes up in court, it is heard timelessly and on the merits, and at the end of the day, justice is done. Thank you for listening.
Thank you very much. Thank you very much, Senior Magistrate Rita Eaton. She had made a presentation and she highlighted the legal framework for speedy trial. She did that some of the reforms under the Administration of Criminal Justice Act, and then she went on to identify the factors responsible for delays, many of which we are familiar with, and then she ended with her suggestions. Two particularly are of interest to me, and maybe we can look at it when we go into the discussion session. She gave the instance of close liaison between prosecutors and investigators. And that's a practice that has been adopted to some degree of success in Lagos. At the DPP's office in Lagos, you have 2 police officers who are stationed in that, and that has been able to, ensure that things move a little bit more speedy. And then she also made one which has been very current, in legal circles recently. Create specialized court. Everybody wants specialized court. Taxation, specialized court. Economic crime, specialized court. Election petition. At the end of the day, there will be no regular courts. So I think that's an issue that we need to look at. If we improve the general overall administration of justice, we will not need specialized courts. Anyway, we can make our comments on that when we get there. We want to thank you very much for your presentation, and I understand you are online, ready to take comments and questions. So quickly, I can see the chair for the next session already seated, so we need to move on quickly and try and wrap up as quickly as we can. The last but not the least presentation is on trial within trial as a clog to fostering speedy trials. And it's going to be made by Asamil Mohammed Suleiman. I've given everybody 15 minutes, but if you can do it for us in 10 minutes, we'll be very grateful, and we'll give you an award for that. So you can make your presentation.
Within a lot has that cannot trials, courts, particularly lot of this trial within when such has system. Practice allow for take place. Speedy have the where we have this right to but is particular point constitution silent. We have the right, even you are guilty or not guilty, silent. However, once an accused person or a suspect or the police, when within value when the prosecution statement exhibit as to that so therefore and then the court will ask the court will just move to allow them. That is the these statements scholars and other evidence that because the as a court beyond reason that is can court beyond without trial. So the main trial will be another trial will just to one thing that very sorry this such process have all happened because trial acts that it consumes the time of the affect the quality after long process. I don't think the judge will still trial as otherwise. Then it elongates the time. This I it is up to 2 are still in trial within, have not moved. So it's more detrimental to the that it also caused the government those witnesses testify during trial with trial will come or other witnesses and the which means evidences that were adduced at after while made proof. Any person out the process of calling witness beyond reason. The defense can actually prove that that statement. They can cross-examine the witness to whom the is sought to be tendered. They can look at the time frame in which the defendant said to have given that purported constitutional statement. Because at times you see that he was cautioned on 16th, for instance, and he signed the statement first. So you don't need any magic to tell you that he must have gone through various trainings to write that. By those training, I mean coercion, threat, and use of force. So even the people, ACGL has provided that statement should be made in presence of certain people. Those persons that were present could also be called as witnesses of the defense, and he could testify that yes, he was coerced, or the statement was not voluntarily made. So it is evident that trial within trial is time-consuming for the court, the prosecution, defendant, and it is said that to ensure speed of ACG should be strictly adhered to, and old practice abandoned. The judges should see that the provision of ACJA, particularly section 1517 and 396 are strict. That and for those that have it, they should up and do it, saying that the ACL is fully implemented. NGOs like jury and other cohort members also called on to rely on the committee and assist. And another thing that will be of interest to us is that in Botswana, that once a confessional statement for a police in every, so it has to be made before a magistrate or a judge or any officer who is not a. So you see, this is something we could borrow, because it is a well-established fact that you cannot separate the police from use of force. So I think the best thing that we can do also is avoid using the police to get statement of the accused. Take the accused to the presence of magistrate, justice of peace, just to make his confessional statement if he has anything such to say. And he should also be cautioned that making such statements is not compulsory. Just remain silent. Let the prosecution prove their case as it is. Thank you, and good morning once again.
Yes, thank you very much. We will give you an award for doing it in less than 10 minutes. Thank you very much. I mean, our presentation is very clear. Trial within trial occasions delay. There are time to introduce provisions saying it must be recorded on electronic, it must be recorded before it has not worked. And I particularly like at the point at which she ended. That has been the position in India. All these years, you cannot make a confessional statement before police officers. The law provides that it is only magistrates that can take a confession. So how a magistrate will be involved in now torturing the offender, you know? So I think that is the way to go, because some of the other decisions on whether if you don't comply with the provisions in the ACJ, you know, whether it is admissible or not, whether it's infringing on the powers of the National Assembly to make laws under the Evidence Act, we don't even need to get into that at all. We just need to amend the provisions of the Evidence Act and say that confessional statement should be taken before magistrates. And if we need to appoint more magistrates, we should. If India, with a population of almost 1 billion, has been, yes. Oh, it's even over 1 billion. If India, with their population, can manage that procedure well, I believe it can work here also. The trial within trial thing is just an unnecessary delay. And I'm quite happy that you mentioned the Botswana approach, which also mirrors the approach in India. Thank you very much. Let's give a big round of applause to all our presenters. Now we are brief period of interaction, and then we'll give them 2 minutes to say their final words. Please, I want to encourage us to try and, process our questions in our mind before we ask them, so that we can make them as brief as possible, so that we can move on to the next session. So just tell us your name and go straight to the point. Thank you very much. If it's a comment, if it's a question, then you should direct it to any of the presenters. And if it's a suggestion, then you can make it. Thank you very much.
My name is Nanaya Frimpong from Ghana, Justice of the High Court. Now, at this question, go in Ghana, he was saying that in their country, a judge can also start his own investigation as part of his duties to find out evidence. Now, how does he incorporate that evidence into the proceedings when a judge is not supposed to descend to the arena of conflict? For example, there is a case, I go there, I find my own findings, and then I come to sit over that case. It's not going to be prejudicial. Am I allowed to introduce that evidence into the proceedings? And how do I write my judgment without making a comment on what I have found out?
Okay. No, I think the question is that, he said in your own system, you said the law allows the judge to, yes, from the judge will appear to have descended into the. So you will respond to it when we've gone around. Please, when you are making a comment or a question, please mention your name and the organizations that you represent. Thank you.
Okay, thank you. Good morning, everyone. My name is Ogechi Ogu, and I work with Prawa. So I'm speaking to the presentation around plea bargain. And I want to find out the connection between plea bargain and restorative justice. Factor of the victim there, but most importantly, how plea bargain corrupt cases and victims, and what do we do to bring in, especially for corruption cases, who are the victims? How do we get the interest of the people, especially in issues of corruption? Because most of those cases affect the general public. So how do we play into this to get the opinion of the people regarding cases like that?
Okay. Thank you very much. So I will allow my Lord to respond to that at the appropriate time. And if need be, I can also make 1 or 2 interventions. Yes, the distinguished gentleman from the Correctional Service, and then after that, our colleague from University of Ilorin.
My name is Ruler of Corrections, E.A. Nwakeze. My question or comment is on the issue of making a confessional statement before a magistrate. To me, I think theoretically it looks very easy, but in real practice, is it easy? Knowing fully well that maybe somebody in most of these remote places, policeman has arrested somebody on the scene of a crime, and he has agreed, he said, yes, Namiduam. And then before you take him to the magistrate, maybe in their town, Don't you think that within this time, his colleagues must have encouraged him to change or her statement? Now, modify it, tutor it, doctor it. So I think we still look at it again. It may not be as easy as, considering the remoteness of some of our sites of crime. Thank you.
Thank you, sir. So that will go to our colleague from the lady, and then.
Thank you, sir. I'm abroad. Now, how can we reconcile the plea bargain vis-a-vis Section 36 of 5 of the 1999 Constitution, which, of course, presume the accused person or defendant innocent until the contrary is proved? So that is a question that I need answer to that, or maybe probably if we can call for the amendment of that provision of the Constitution, because it's a constitutional right that is guaranteed. So if, at the end of the day, somebody admits guilt, then that means there's no more proof beyond reasonable doubt. That is my belief. Then secondly, in respect of plea bargain, in the Nigerian situation, especially in our criminal code, most especially I think sections 127 to 130 of the criminal code in Nigeria, we have compoundable and non-compoundable offenses. I mentioned this yesterday. There are some non-compoundable cases that you cannot just go to court and say you are withdrawing it based on maybe probably you need compensation or you need to substitute the offense to lesser one. So these non-compoundable cases have to be looked into as well if really we want plea bargain to be effective in Nigeria.
Okay, thank you, ma. 2 questions so that others will also have the opportunity. Thank you. Because the way you are going, you end up with 4 or 5 questions. We can do the rest over tea or over lunch.
Okay, thank you. I'm DCP Simon Lowe, Senior Advocate of Nigeria.
Oh, okay.
Yes, my comment is so many years, and in more than 100 cases that I have prosecuted that involve trial within trial, all the statement has always been admitted. So at a point, I begin to think that it is not even necessary for us to even embark on trial within trial at all. Because Section 28 and 29 of the Evidence Act empower the court or give the court the discretion to decide whether the statement is voluntary or not. And I believe that can even be done in the course of trial. Because from the testimony of witnesses, the court can even come to the conclusion that the statement that was made by the court was voluntary, but the suspect was voluntary. Because in most cases, most of these accused persons, they will make statement voluntarily. But just as my colleague here said, in the course of the trial, they will be tutored either in the prisons or even by their counsel or even by their friends. And at the end, they will deny. And when evidence are called, you discover that there was not even touch after all. So that trial within trial, it wastes a lot of time. And I think there's a need for it to be abolished. I've suggested in several fora that it should be abolished. Because first of all, it's not even in our law. It's not provided for in any of our law. It is just a practice. And as a practice, we can even dispense with it. And then on the issue of plea bargain, I also shared the same view with my learned friend who said Section 35, presumption of innocence. But in the case of plea bargain, it is the defendant who is charged that normally call for even plea bargain, not even the prosecution. Because in cases that are prosecuted, all the plea bargain that we did were by the accused person. So the presumption of innocence does not even affect his plea bargain at all. So I don't think that issue will arise.
Thank you very much,
yes,
sir.
Thank you very much.
Thank you for responding to that. There's a hand at the back, and then, okay. The organizer needs to advise me how much time we have more. Please, I need to be advised.
Please, mine is still also in respect of plea bargain, of corruption, and from public office holders. Don't you think it is not enough for the person to just plead guilty and then return the stolen goods? Because corruption is a crime of opportunity.
Okay.
So I think there should be a legal framework and even policies in place to subject such offenders to some degrading community service. So we should emphasize on how to stop those who will have this opportunity, maybe holding public offices, from stealing our public money by subjecting them to degrading community service. And that will go a long way too.
Let me quickly respond to that. While plea bargaining may have emerged.
My name is Christy Edwards,
Okay.
a study fellow of this great institute.
Okay. While plea bargaining may have arisen from EFCC cases and corruption cases, it has actually gone beyond that. In Lagos State, DPP do not prosecute. So it only began from corruption cases. It can actually be done in relation to any case. Okay? Then the other issue you raised about plea bargaining in corruption cases, of course, we now have sentencing guidelines which have evolved in almost all the states, guiding the court on the procedure the court should follow, the factors the court should take into consideration. So the fact that you are pleading bargain in a corruption case does not mean you are going to go scot-free. The court will still evaluate the gravity of the offense, aggravating factors, mitigating factors, and take all that into consideration before arriving at the sentence. So let me quickly just say that. All right, so we'll take 1, 2, 3, 4, and then we'll. By 11:30.
Thank you very much. I'll
Yes.
be brief. My name is Muchania Tamundopa from UNODC. I just wanted to commend the speaker from Rwanda and my lady for buttressing 2 points: the role of the actors within the criminal justice sector, as well the issue of bail. I think we have an issue where police arrest to investigate instead of investigating then arrest, which leads the courts are now forced whether to grant bail or not, and in most instances, the excessive bail that the courts then grant amounts to a denial of bail itself, putting pressure now on the prison, on the correctional service. Thank you.
I agree with that. Onerous bail condition is tantamount to denial, maybe tantamount to denial of bail, which complicates the correctional services challenges. Yes?
Good morning. My name is Victor Chapi. I am a duty solicitor and a member of the Nigerian Bar Association. I'm a practicing lawyer here in Abuja, and I actually came late because I had a matter in court this morning. And sadly, I got to court to find out that the court was not going to sit for one reason or the other. It's not the first time or the second time or the third time. So I was touched when the senior advocate from Rwanda said in Rwanda, they have an integrated system, online platform, where cases are managed. The court is present, litigants are present, counsels are present. You can put in a request that you will not be in the country or you will not be available like he did. And then your matters will be adjourned. All parties are aware. So I don't know whether this is the right platform to say this, because we'll continue to have delay. Justice delayed is justice denied. We continue to have delays both in criminal matters and civil matters, and we will never get the issues addressed. Nigeria should be a forward-thinking country. I'm sad being a Nigerian saying this. So I think, I don't know if it's
Don't be sad. We'll get better.
Thank you very much.
Don't lose hope. That's why we are here, because we have not lost hope. Yes, quickly.
Okay, my name is Ruben. Imara, legal practitioner. I'm with the Nigerian Law Reform Commission. Okay, the issue that we are talking about, trial within trial. And one of the presenters, she rightly said that that ACJA tried to cure those anomalies. Can we import the provision of that ACJA to the Evidence Act? Because ACJA is just jurisdictionally constrained to Abuja. So can we just import it to that so that the confessional statement can be made before a legal practitioner or is representative of the defendant? Thank you very much.
Okay, thank you very much. So the last but not the least, then quickly we'll give the speakers 2 minutes to quickly respond. Okay, that's good.
Okay, he's online. Okay, so Taiwo, my question is to you. And I am trying to draw the line between where big data and predictive algorithm, especially when you bring it into legal system. It was tried in America, and they discovered that blacks, Hispanic, and other minority groups who are more prone to crime were the data always predicted that they would commit more crime. So if you bring that to Nigeria, of course, we still have our peculiarities and our tribes. That could also be applicable. And then when you take lessons from Netherlands, where at the moment they're already working on neurotherapy, which goes into the mind of a person to correct that part of the brain that is prone to crime, then I ask, where do we then draw the line, and where do we hold people accountable for evasive procedures like that?
Okay, thank you very much. So I will start from my Lord Judge Evra Luswata to give a bird's eye response, if that is possible.
About plea bargain, I did mention that plea bargain is actually a hybrid. It's a hybrid of the plea of guilty. So like he said, it is initiated by the accused person after probably talking to their lawyer, looking at all the odds against when you give up your right to a trial, your right to innocence. It is a matter of choice. And when you said about restorative justice, its involvement of victims is a must. And once you involve a victim, you're already pointing towards restorative justice. Sometimes even the family sit together and discuss this, and they go home happy. So to me, that is already restorative justice. In matters of corruption, it is a crime like murder. It's a crime like any other. So if you're going to offer it to one, you must offer it to all. And remember, in many cases, especially in Africa, where our investigations have a problem, the prosecution has a bad case anyway. There's a possibility that this man could have walked free. And now they are offering you a plea of guilty. So they have a right to negotiate. The prosecution must also be giving something back to this person. They have relinquished their right to a trial and innocence. They should not just be then sent to the goals. Thank you.
Yes. Can't hear you.
In your presentation, you said that in your country, it's only the DPP who can end the case. In Ghana, we have a similar thing by the attorney general or the senior person in that department. But then the effect is that why can't a judge strike out a case that has been on the list for a very long time, which has not seen prosecution and accused is still in court? In our case, the effect is that the case can be struck out for want of prosecution by the judge, but it doesn't take away the fact of a rearrest and going through the same process again. So we have to address that area, that if a case is delayed for too long, the judge can just dismiss the case without the right of the prosecution, rearresting the person and putting him through the same process again.
I know that Ghana's legislation should be, really identical to the Ugandan ones. Yes, that the judge can discontinue proceedings, but usually they only do so when the matter comes up for trial. We don't do it before that happens. But the DPP always has a right to rearrest because you have not gone through a trial. Usually they don't.
Thank you, Chair. My Lord from Ghana. I just want to mention that in our system, judges in Rwanda can visit the scene of crime and hold trials where the judges in Rwanda can hold trials where the crime was committed, as long as it is within the jurisdiction of that particular court. And the thing is that they call it itinerance of judges. So why? Because we have what we call homegrown solutions in our country. I mean, we have had lots of problems in the past. Things are now on the right path. Our judiciary is really catching up very well, meeting standards that are required. But remember, this is a country where international crimes were committed only 28 years ago.
And we had several detainees, and the issue of a speedy trial was actually far in sight. So going to the scene of crime was part of, we find lots of solutions within our systems back home. And going to the scene of crime, either when the prosecution has not been able to explain their case very well, and maybe the judges want to go there and see witnesses or scene of crime or how the crime was perpetrated, what happened, in order to come up with a just decision as it should be. However, back home, by sharing experiences, we have lots of things that we do that may not be applicable in other countries that support the judiciary and other law enforcement agencies. We like to call it homegrown solutions, because when you are faced with a crime like genocide and you have to find answers within the judicial system that was very weak in 1994, 28 years later, we are now talking about building a strong judicial system, reforms and all that. So it's a procedure that does not affect anybody's independence, and any decision that comes up is fair, as it should be. Thank you.
Theirs is more of a combination of the adversarial and the inquisitorial system.
Okay. Responding to the first question that said that they could change their plea on their own, I think we should not forget that the person has the right to be silent. Whether he pleaded guilty or not, his duty to prove his innocence. He is there on a trial. The prosecution has the duty to do that. Even if he has pleaded guilty and retracted his statement, and you get to court, it is your duty to prove that case, not his. We have seen cases of this school proprietor that kidnapped the school girl. He has confessed all over the media. But when he got to the court, in fact, the law is that in homicide cases, once it's death sentence or life sentence, even when you say you are guilty, what is going to court, plea of not guilty for you. So there is no problem in changing the plea or not. And Leonard Silk, I was trying to win the chairman's award. That was why I cut out some things. Like this issue of admitting evidence during trial within trial. It has happened to me on several cases, but at times you feel like you will be cheated when you allow this thing to go without going through the rigorous process of trial within trial. But over time, I have come to realize that you don't even need that. You don't need to go through that process. You could prove it, and then it is left to the court. And most times, aside from admitting it, it also clouds the judge's judgment of being an umpire, because from all the testimonies he had, he has believed that you have committed that offense, not just that he has admitted the evidence, because hardly you will not see conviction after that.
Thank you very much. So let's have Mr. Taiwo Abiodun Oni, if you are still online.
Okay.
Thank you.
Good afternoon. I don't know if you can hear me clearly.
Yeah, we can hear you.
Okay, so before I go ahead to answer my own question, I think I would like to address.
In 1 minute.
Yeah. So the trial within trial question that has been going around, it can be solved with artificial intelligence. There are lie detecting artificial intelligence tools that helps to look at pupil dilation and blushing and all of that to detect whether a person is lying. So whether a witness, a defendant goes back on his previous statement, the court can tell if he adopts the artificial intelligence to detect the lie. So that would solve the trial within trial. And also, for the question the lady asked, of course, one of the reasons why the U.S. court adopted the COMPASS system, that's the correctional artificial intelligence tool, was to stop the bias on blacks. Because blacks have, according to records, blacks have like the propensity for recidivism. So they felt like it was unjust because most blacks would definitely be denied bail than whites in the US. So the artificial intelligence tool COMPASS helps to reduce or eliminate the bias, the racial bias of Asians and blacks in the granting of bail. So I think that kind of system would help take care of the tribal sentiment that you think we have in Nigeria. It makes it objective. It makes the process of granting bail and the process of other judicial process involved with humans to be more objective.
Thank you very much. Thank you very much, Mr. Taiwo Olabode Oni. I mean, on the final note, before we get into using artificial intelligence to predict judgment, I think we should focus on some of the basic things that we can use it to do. By now, all motions, contested or uncontested, should not come up in courts. If we are able to do that, we will save a lot of the cost in running the courts. All appeals, no appeal should come up in Court of Appeal or Supreme Court anywhere. The lawyers should join for wherever they are. Those are the basic things we can do. The only thing we can say for now we want to do physically is trials. We must embrace technology. And it will help us solve some of the funding problems. Anyway, so I think that's a food for thought. I want to thank all our presenters, starting from Judge Evan Luswata, Court of Appeal Uganda, Senior Advocate Jean Boso Mutangana from Rwanda, Senior Magistrate Rita Eaton from Cross River State, Mr. Taiwo Abiodun Oni from Babcock University, and our colleague Asmau Mohammed Suleiman from the Nigerian Law School. We want to thank you all for coming to make your presentation and joining us virtually. I want to thank the audience as well for your active participation. I think we should give the panelists another round of applause. Thank you very much. So I think
Mr. Roger will have a group photograph with the panel.
Good.
No. Or maybe by Photoshop. Thank you very much, ladies and gentlemen, our distinguished participants, my lords, Honorable Silks. The time is already very well spent this morning, and we are a bit behind our schedule. It's for this reason we'll be having a 10 minutes tea break session. Please, we can just go quickly to the Aloma Mokhtar Hall and grab our tea break items and maybe just return to the hall so we can start off the next session as soon as possible. Thank you very much. The tea is served. Thank you.
professors, academics in the house, ladies and gentlemen, you are welcome back to the next session, which is the second working session for today, and is on restorative justice and criminal proceedings. And our chair for this session is no less a person than Dr. Akeem Bello, an associate professor, Faculty of Law, University of Lagos. Dr. Akeem, we are happy to have you once again to chair this session. Please, a round of applause for him. As our chairman gets seated, I have the honor and privilege to invite to join him on the high table member of this panel in person of Dr. Suzy O. Oyakire. You are welcome, ma, from University of Benin. I also invite the representative of Osareme Grace Omoruyi, Mr. Chibueze Noel Maduka, to join them on this panel. You are welcome, sir. I have the singular privilege to invite to the high table Dr. Habila Azad and Awele Ikobi, Senior Research Fellows at the Nigerian Institute of Advanced Legal Studies. You are welcome, sir, and ma. You are welcome. So, Mr. Chairman, can commence the session. Thank you very much, sir.
Good afternoon, ladies and gentlemen. Well, welcome back to the second session. This session is supposed to be chaired by Mr. Chinoye Obiagu, Senior Advocate of Nigeria, but he has sent his apologies to the organizers of the program for certain challenges that made it impossible for him to be able to attend and chair the session. So the organizers have requested me to share this session. The session is on restorative justice and criminal proceedings. Restorative justice and criminal proceedings. Of course, we know that traditional criminal justice system that we inherited from our colonial overlords places a lot of premium on the retributive approach. The focus was on punishing the offender. The focus was, adopting the law of Moses type of an eye for an eye. But we all can see that that approach to criminal justice has encountered many challenges. And we have seen that that approach to criminal justice focuses on punishing the offender. Whereas there are other interests in the criminal justice system that needs to be protected. And one of those interests is the interest of the victims of crime. So the retributive approach focuses more on punishment and leaves the victim out of the picture. In addition to the victim, there is also the society that feels the impact of the crime. If there is a theft in the neighborhood, if there's an armed robbery in the neighborhood, you may not be able to sleep comfortably again as you used to sleep comfortably in the past. So crime also affects members of the community. So in the last 5 to 10 years in Nigeria, we have begun to see that the focus of criminal justice is now shifting to a more integrated approach of including restorative justice as part of the process of criminal justice. Yes, we cannot completely do away with or punishment because most people's perception of dealing with crime still requires punishment. But in addition to that, we need to begin to focus on restorative justice. And in Nigeria, in the last couple of years, there has been a lot of move in this direction. Particularly, I know in Lagos, there's a lot of move in that direction. The criminal law, the substantive criminal law, and the Division of Criminal Justice law has made provisions for the use of restorative justice outcomes. And I believe also that under the federal ACJ and the various ACJLs applicable in various states, there is also a focus on the use of non-custodial sanctioning methods, many of which are restorative in approach. So today we have an eminent group of panelists who will do justice to the topic. We have will be joining us online, Mr. Mike Bentley, the CEO of Restorative Justice Center, South Africa. I know Dr. Mike Bentley is a restorative justice practitioner from South Africa. I'm not sure he's the one that came to Lagos a couple of years ago where we held a restorative justice training, which we had in Lagos some years back, because I know somebody came from South Africa. So he will be joining us online, and I'm sure we will be enriched listening to his presentation. Also, we have Dr. Susie O. Oyakire from the University of Benin, Senior Lecturer, University of Benin, who will be making a presentation of victim protection and restorative justice in criminal justice administration in Nigeria. Then we also have another presentation titled Criminal Justice Administration, the Nigerian Correctional Service and the Law, a case for restorative justice. The presentation is supposed to be made by Osarieme Grace Omori, but Mr. Chibueze Maduka is standing in to make that presentation. Then our colleague, Dr. M.A. Abdul Rahim Mustafa, Associate Professor of Law from Faculty of Law, University of Ilorin. You can please join us now on this side. She'll be making a presentation on widening the gap, interrogating the exclusion of female offenders in postal institutions in Nigeria. And then, yes, let's give her a round of applause. And then the last presentation will be one titled The Rights of Victims in the Criminal Justice Process, How Real, by Dr. Abila Adzad and Awele Ikobi, Senior Research Fellows, Nigerian Institute of Advanced Legal Studies. So this is the way we're going to proceed. Each presenter is going to have 10 minutes. But if you're able to do it in less than 10 minutes, there is a greater reward for that. Institute, you have two presenters. You have the option of sharing it 5 minutes, or as you may choose to decide. No, it has to be 5 minutes. But what is important is that we've run far into the other session, and Professor Isabella Okagbe has been waiting. I actually thought our session was the one after mine, but our session is the last for the day. So let's try and make best use of our time, focus on the critical issues, and then we'll be able to discuss. And I can assure you that we are going to have a wonderful time. Thank you very much. So right away, I will call on Mr. Mike Bentley, CEO of Restorative Justice Center, South Africa, joining us online. Is it recorded or is it online? You're welcome, sir.
Good day. Thank you so much for the opportunity to be with you today. I really appreciate the opportunity and the invitation. I've put together some slides.
Sir, you have 10
so
minutes,
let me
sir. I
just
hope you
get
had
those
that.
going.
Yes, we can see your slide.
A quick word about where I'm coming from. As you know, my name is Mike Batley. I'm based in Pretoria in South Africa. I'm a social worker by profession, and for the last 20 plus years, I have led a local NGO called the Restorative Justice Centre, where we've tried to play an active role in promoting restorative justice in general public discourse, as well as in the specific legal context. I'm only able to speak from the South African context. I'm not familiar with other sub-Saharan countries and their legal framework, but I do hope that this will be helpful as a point of reference and that you'll be able to apply that and adapt that to your own specific legal framework. I always find it useful to make these distinctions when we use the term restorative justice. First of all, restorative justice is an approach, a way of thinking about crime and justice matters. Then there's the term restorative justice processes, which is a phrase that's used in the UN handbook, and that refers specifically to the idea of bringing parties together in some sort of encounter, usually with the use of a facilitator. And then we have a range of other interventions, programs that are based on a restorative approach. These could be for offenders or for victims, and could be things like life skills programs, vocational programs, or therapeutic programs, which would not typically then involve the coming together in an encounter, as we refer to under restorative justice processes, but they would be based broadly on restorative values and on a restorative approach. Sometimes we use these terms interchangeably, so I think it's useful to pause and check exactly what are we meaning, what are we referring to when we use the word restorative justice. This is a graphic from the UN handbook, and it's very helpful in identifying and clarifying the points in the criminal justice system from which cases can be referred for restorative justice processes. So just going through them quickly from left to right, these would be cases not coming to the attention of the criminal justice system. They would be informal referrals and done basically just with the consent of the parties. Then at a pre-charge level, so no formal charge has been submitted, but perhaps the parties or one of the parties has approached the police and perhaps the prosecution are involved informally, but there's no formal engagement of the system, but at that point the parties could be referred for a restorative justice process. I think where most of us are familiar and where it generally happens in most countries is at a post-charge, so a formal charge has been opened, been some investigation, and it has been submitted to the prosecution. And the prosecutor then exercises some discretion and decides that the case can be appropriately dealt with by a referral to a restorative justice process, but it is the rest, there's no formal trial that proceeds. So it is still an informal referral. One step beyond that would then be a trial has been held and there has been a conviction, or there's a formal trial perhaps, but with a formal guilty plea, not necessarily with leading evidence, but there has been a conviction. In the previous one, there would be no conviction and so no criminal record. But at this point, there is a conviction, so there's a criminal record, but it's pre-sentence. And either the prosecutor or the court could refer the matter for a restorative justice process for assistance in crafting a suitable sentence. And it's going to be at this point that I'm going to go into a bit more detail, because I think that that hopefully will be the point that you will be most interested in. But I thought it was useful to provide this broader context to locate this. And so just continuing with that then, at a post-sentence stage, but pre-integration, so these would be probation or correction referrals, or corrections or prison referrals for a restorative justice process, perhaps as part of preparing for release, part of a parole board hearing, where the parties meet. And it's not going to change the sentence, but it could influence the date of release. And then post-confinement reintegration, this would be after a person has been released as part of the parole agency or an NGO that is involved. There's an initiative to bring the parties together. So that is after the person has been released, as opposed to prior to the person has been released at the previous level, but fulfilling much the same purpose and assisting with the reintegration of the offender into the community and the repair of relationships. I think that provides a very useful picture, an overview of the various points in the criminal justice system at which cases can be dealt with in a restorative way, as we typically understand of the parties coming together. A couple of important points of reference that are articulated in the UN Basic Principles and the Handbook. First of all, there must be a prima facie case. If there isn't a prima facie case, then the prosecutor shouldn't have any business referring it. Secondly, the accused must accept responsibility, which is not the same as a plea of guilty, but as long as the accused is not denying responsibility or saying, wasn't me, wasn't there, that's the case. It's also not suitable to deal with that in a restorative justice process. In that case, the case should then proceed to trial, where the person could plead not guilty, and then there would be a verdict. The handbook also speaks about or stresses the voluntary nature of participation, and also the transparency of prosecutors. So I'm not sure how often this happens or whether it necessarily is well done, given some of the time pressures that prosecutors are under. But I think that as far as possible, there should be some transparency. The prosecutor should inform complainant, the victims, about the decision and why the decision is being taken to refer this for the possibility of a restorative justice process. And I think it would be important to note that once the facilitator, the mediator, engages the parties, they may then conclude for a number of reasons that it's not appropriate to proceed. But at this point of referral, the prosecutor is being transparent about the fact that he or she is referring it and the reasons for that referral. You'll recall that at the heart of restorative justice, this is what Howard Zehr in his documentation, specifically his little book of restorative justice, calls the justice flower, and he has as the fruit of restorative justice at its center this idea of putting right, which requires that we address harms and that we address causes at all levels, whether that's at a personal, interpersonal, or more widely at an environmental or societal level. And these are at a values level from Leroux versus Day. The court said it was referring to our underlying value of human dignity. Respect for the dignity of others lies at the heart of the Constitution and the society we aspire to. That respect breeds tolerance for one another in the diverse society we live in. Without that respect for each other's dignity, our aim to create a better society may come to naught. It is the foundation of our young democracy, and reconciliation between people who opposed each other in the past is something which was and remains central and crucial to our constitutional endeavour. Part of reconciliation at all different levels consists of recantation of past wrongs and apology for them. That experiment has become part of the fabric of our society. The law cannot enforce reconciliation, but it should create the best conditions for making it possible. We can see no reason why the creation of these conditions should not extend to personal relationships where the actionable dignity of one has been impaired by another. And so this was a case of crime injuria, where one of the parties felt that their dignity had been seriously impaired, took the matter all the way to the Constitutional Court, and the court then ordered an apology. And those are the comments that they made.
Mr. Mike?
I hope we have time for some reflections and questions, and I'd be happy to entertain some of those.
Thank you very much. Thank you very much. Thank you for making it so snappy. Thank you very much. We have listened to Mr. Mike Bentley. He had started by giving us a definition of some key terms, and then went on to that diagram which points to the stages at which referral to restorative justice may take place. And we can see that it goes through the entire spectrum of the criminal justice, from pre-charge to post-charge to pre-conviction to post-conviction to pre-sentence, after sentence, and after the offender has committed the offense. So there is possibility all through the criminal justice system from his presentation that we can see. So we thank you for that presentation. That graphical illustration was quite illuminating. Thank you very much. And then you also mentioned some basic preconditions that must exist before RJ takes place, admission of responsibility by the offender, there must be a prima facie case, and so on and so forth. Thank you very much, sir. So quickly, we would like to go on to the next presentation by Dr. Susie O. Oyakire on victim protection and restorative justice in criminal justice administration in Nigeria. Thank you very much. You have 10 minutes also.
Good afternoon, everyone. To make my 10 minutes, I could just say I adopt everything the chairman has said and we'll be fine. However, I have to do my duty. Just by way of introduction, restorative justice is not limited to victims, even though my topic says victims, but you'll find that even in the course of the conversation, we've also focused on the offenders. So my presentation speaks to a larger paper, 6,500 words. So I'll just be giving you like a brief overview of what the paper contains. By way of the objective of the paper is to discuss how we can achieve the objectives of restorative justice in Nigeria, especially victim participation in criminal justice processes through victim protection. So we are looking at the participation of victims, and my argument is that to achieve that, we'll need victim protection mechanisms. Okay. Okay, so by way of introduction, not to reiterate what everyone has said, that the aims of criminal justice in Nigeria has focused on retribution and, of course, the rights and interests of the victims, of the defendant. And so we'll find that recent reforms in criminal justice administration, particularly with the enactment of the Administration of Criminal Justice Act, has incorporated more restorative justice approaches. And we're looking at the victim protection. So we have Section 1 of the ACJA that has brought the interest of victims to the fore. Look at the objectives of the ACJA is one of the objectives. And these reforms in the ACJA indicates a shift from the extremely retributive justice system to one that incorporates more restorative justice principles. And victim protection is one of the inclusions in the ACJA. So we'll begin the conversation by defining what the restorative justice process is and the objectives. So the UNODC has defined the restorative justice process as a process in which the victims and offenders, and where appropriate, any individuals or community affected by a crime participate together actively in resolving the matters arising from the crime. And so in resolving the matters, we have the participation of everyone, not just the retributive system looked at the state as incorporating the interest of the victims. The victim was the state. And so whatever the state decides is what actually would represent the actual individual that has been affected. But with the restorative principle, we try to look for who the victim of crime is, the offender, and the community. Everyone should participate in the process. And so the restorative justice principle emphasizes the needs of victims of crime, the offender, and community, rather than just focusing on punishment. It underscores the participation of the different parties as an essential process in facilitating reconciliation between the victim, offender, and community. So these are all just objectives underlying the restorative process. But my paper is saying that there are several objectives, but what my paper will be looking at is, the victims should be, the participation of the victims, and they should be given an opportunity to express their needs and participate in criminal justice processes. However, the problem is that in participating in the processes, they're exposed to certain forms of victimization and secondary victimization. So who is a victim? It's very important to know who the victim is, and we'll have our definition under the UN Declaration on Basic Principles of Justice for Victims of Crime, 1985. Article 1 and Article 18 provide a definition. Any person who individually or collectively have suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts of omissions that are in violation of criminal laws operative within the member states. So in my presentation, I've highlighted that the ACJA does not define a victim. However, we have a definition in the VAP Act, the Violence Against Persons Act 2015, in section 46 defines a victim, but basically adopts the definition under the UN Declaration. So if we say victims must participate, what laws give that, what is that a law that gives them the right to participate? By way of definition, participation just means the act of sharing or taking part. And you find that the UN Declaration is saying that in many ways, the right of victims to participate or the right of the victims to be heard is central to the rights of victims. And the right to participate is seen in Article 6. Just to know that this principle, UN Declaration principle, is just a soft document. It's not binding. It's something that states should aspire to do. And so Article Section 6 or Principle 6 of that UN Declaration just speaks generally to the right of victims to participate in criminal processes. The participation could take place in several stages, as the previous speaker has said: filing complaints, pre-trial, which will include investigation, and plea bargaining. If you see our provisions in Section 270, they must be part of the plea bargaining process as witnesses, and then in post-trial, in sentencing aspect. So victims take up different roles from the beginning of the criminal justice process down to the end, and this could be as complainant, as informant, or as witnesses. Now, there might be reasons for non-participation. You'll find that our victims, regardless of the law is beautiful, but you find that are they really participating in the criminal justice process as envisaged by restorative justice principles? There are several reasons for this. A specific reason is the very nature of our adversarial system that limits the role of victims already. Regardless of what has been said, the state still actively takes up the responsibility for the victims. And so the victims, by the way of our adversarial systems, are already excluded. However, I'm focusing on issues such as the victimization and secondary victimization, which I'm sure most of us can relate with in different ways. So what is victimization? Victimization refers to the suffering of physical, financial, and emotional injury done to the victim or anything that aggravates the suffering, harm, or injury that is being done to the victim. Basically, it's divided into the primary victimization and secondary victimization. The primary victimization is the actual offense that the victim suffered: stealing, rape, murder. Those are the primary victimization, the actual offense that the victim was exposed to. However, we have secondary victimization, which the Council of Europe defines as the victimization that occurs not as a direct result of the criminal act, but through the response of institutions and individuals to the victim. This is very peculiar because you already have suffered something, and then in the course of trying to report your victimization, you suffer further victimization by the very institutions that should protect you. For example, the police. You go to report stealing, your car has just been stolen, and then they ask you for money to open the investigation. Or you have been raped, and the police officer is victim, he's shaming you. Probably you wore shotgun, or you went to the man's house at night. For other people, it could be that they'll say, why were you withdrawing your money? Why did you withdraw more than 50,000? You wanted to boast that you have money. Something has happened to you, and then the people who should help you are further victimizing you. So I've given examples of secondary victimization, where victims are discouraged from reporting certain offenses, sexual offenses, for example, due to social stigmatization, where police demand monetary inducements before investigating the crime, repeated exposure to the victim to the offender. So you find that we don't even have processes where we can prevent the victim from seeing the person that has offended them or violated their rights. And we have even the media focusing on the actions of the victim rather than the person who committed the crime. And so we start looking at what did the victim do or what did the victim not do. The victim has not cried. The victim is attending a party. All those things are secondary victimization, which most of us can relate with. So I'll just go on to say that the various forms of victimization could be physical, economic, and psychological. Therefore, we require measures that will protect us at these different categories. Victim protection will just be defined briefly as the rights, set of rights and guarantees that aim at preventing any further harm or intimidation of the victims, either because of a subsequent crime or inappropriate criminal proceeding. So the way the defense counsel, for example, will cross-examine a victim of sexual assault, so you provide mechanisms to prevent that. Again, the UN Declaration provides different articles, Principle 6, 14, 16, and 17, that says states should adopt protective measures. In Nigeria, we have included witness protection mechanisms. We've recognized victim protection in the ACJA. And so you find it in section 2321, 2322, and 232 paragraph 3 of the ACJA. But I have in my paper, I've highlighted the different types, which include trial in camera, non-disclosure of the names and addresses of the victims and their phone numbers, and then during court proceedings, evidence by video link, and then it permits victims to be screened or masked. However, there are lapses in our provision. It's not just to incorporate it because it ticks certain boxes. They are limited to procedural protection in court. How do we protect these victims before they get into the court and even after the court? It's excluded in our ACJA Act. It also includes victim protective measures, especially psychological and victim assistance measures. These are very important. These forms of protective measures tackle implicit intimidation, which usually happens in the form of the secondary victimization that I have highlighted. And other measures excluded include use of safe houses, surveillance, and police escorts. We can say that these things are done in practice, but they are at the discretion of the police. They are not institutionalized within the victim protection mechanisms under the ACJA. So my argument is that as long as these things are not available, you will still find that victims will be exposed to victimization. And as long as there's a possibility that you'll be re-victimized or you face secondary victimization, you are not willing to participate in the process. It's almost like I leave it for God. And so the idea of restorative justice that seeks to enforce the participation of the victims in the process is excluded. So I have, by way of reform, that the ACJA, while it's being reviewed, should consider that all forms of victim protective measures, not just the procedural measures that the ACJA has highlighted, should be considered, and it should address all the forms of victimization, financial, economic, mental, and physical. I'll stop here. Thank you for listening.
Thank you very much. Thank you very much, Dr. Yakire. You've taken us through victim protection and restorative justice in criminal justice administration in Nigeria. Yes, she highlighted some of the provisions in our laws that are designed to protect witnesses and victims, and these are new provisions. And also some of the international obligations that we have as a country. And in addition to that, she also pointed to the fact that we need to adopt policies and measures that needs to be put in place. For instance, I know in Lagos, in the office of the DPP, sorry, always making reference to Lagos, that's the jurisdiction I'm most familiar with. I know that they have a witness assistance unit attached to the office of the DPP. They assist to locate witnesses, they assist to, provide all kinds of assistance that the witnesses and the victims may require to enable them to come to court. They need counseling and things like that. So these are all the measures that we need to take, in addition to giving the, as she also said, giving the victim a voice. The victim must be given a voice in the process, although we know that the overall commander in the criminal justice process is the Attorney General and the DPP's office. But at least we should give the victims a voice and a role. Thank you very much for your presentation. So quickly, we move on to the presentation by Chibueze Maduka on behalf of Osarere Grace Omorui, titled Criminal Justice Administration, the Nigerian Correctional Service and the Law, a Case for Restorative Justice. Thank you, my brother. You have 10 minutes.
I think I'll stand on the existing protocols for 10 minutes. Mr. Chairman, I hope to win that today. Our executive director should have been here. She has booked her flight, but because she was bereaved of her father, I have to step in for her. So we are looking at criminal justice administration, and correctional service, and the law, restorative justice. Now, let's look at our general overview. Are we looking today? First thing we're going to discuss is what's the problem of the extant criminal justice system? Why does it have a problem? What are the challenges? Try to make a case on the adoption of a people-centered approach that both repairs the harm caused and restores relationships, and examine current legal framework that allows for the adoption of the restorative justice system, and what are the challenges that practitioners face, and so make our recommendations. So we'll move on to the challenges. So what are some of the challenges we face? Everybody here would agree that crimes are on the increase, and the Nigerian Correctional Service is quite overcrowded. I'm happy that we have some members of the Nigerian Correctional Services here with us. The last time we visited there, it was quite overcrowded, and the last time I spoke with one of their chaplains, telling me about the outbreak call this KBs and some other. So it's a problem, which means that the current system we have is actually not working. If it's working, we won't have that number of persons in the correctional center. Now, many persons have made a case that our current system is retributive, and not just in the, you see that even when you encounter the VIO, you encounter persons that ordinarily shouldn't want to be retributive. Everybody's concerned about you breaking the law. Nobody really cares about what happened, why it happened. Now we're looking at some criminal matters ought not to be in the court in the first place. We're in the correctional center, and then we met a guy that has been in the correctional center for 4 or 5 months. Why? Because he stole a chicken of 5,000 naira, and the person put him there. So some cases are not even supposed to be there in the first place because of the system we have. Now, we talked about 73% of the inmates in correctional centers are actually trial inmates, which means very few persons that have been tried. And now the system, yes, I'm happy Dr. Yakira has made my work easier. She has talked about re-victimizing victims, so I might not spend much time on that. And she has done that already. So I'll move on. What's the case for restorative justice? What's the case for restorative justice? Yakira once again has helped me. She has given us a robust definition of restorative justice. So, but what's the major theory of restorative justice? So it's victim-oriented. So not only is it victim-oriented, we are focused on rehabilitating, both helping the victims, rehabilitating the offender, and integrating them back into the society. So unlike a situation where it is, let us, in the case of Jesus, they say, crucify him, crucify him. No, restorative justice looks at a situation where even if we crucify you, how do you resurrect back again the third day? So that's what restorative justice is all about. You get that point. Okay, now, so therefore, restorative justice addresses victims' needs and enables contrite and willing offenders to understand the impacts of their crimes by asking the following question. So sometimes some of these people, I was discussing with my wife, was it this morning, and I was almost crying when I was saying some of the people that do the things they do are forced by the society that we find ourselves in. And the point is that when we catch them, nobody really cares why they do. Quite all right, some of them are already bad as it is, but some people, they are hungry. Some people, because they see the politicians, what they do, so they do what they do actually. It hurts the society, but yet again, nobody asks why. Right? So what does restorative justice try to do? Restorative justice asks what happened, both to the victim and to the offender. What happened? So we sit down and ask you what happened. So the victim is going to explain. You know, another issue we have with our retributive system is that nobody really sits you down, apart from putting you on the trial stand. Nobody wants to go through cross-examination. She gave a good example of someone that has been raped. Who wants to be cross-examined on that? So by the time you are being cross-examined, you are reliving the experience, which is quite traumatic. So sometimes people are not given an explanation to ask what happened. Then, who was impacted and how? How were you impacted? How did you feel about what happened? That's what restorative justice tries to find out. How do you feel about what happened? Then how do we repair the harm? Right? So ask, how do we repair the harm, both from the part of the victim and both from the part of the offender? And then the most important question, how do we prevent the offender? More often than not, people enter the correctional service centers and sometimes they don't come out better. Don't come out better. If you meet some of them, last time I went there, although it was more of preaching, I was telling them anger, bitterness, because some of them are angry, some of them are bitter. As it's where it seems the society had failed them. I met somebody, he said he was arrested for armed robbery. He has been moved to Lafia. He has been moved to Maraba. I went to the court. I went to all the 4 courts, high courts in Maraba, looking for his file. I could not find it. The person is still there, and we are still going to file a process to see how he is either released or his file is brought out wherever it is hidden. So we're going to ensure that there is no reoffender. The person comes out and the person is better. So some of the principles of restorative justice has been stated in the United Nations Handbook on RJ, and I will not spend time going through that. Our slides are out there, so we move. So if we look at the principles and what the principles is centered on, which I've mentioned earlier on, we realize that RJ had come to stay. From our overview and from our research, we've realized that about an aggregate of 80%, there's 80% victim satisfaction rate and a 14% reduction in the frequency of reoffending in countries that had prioritized restorative justice. So we find out that restorative justice has been kind of better off than countries, and it could even be cheaper than countries that have prioritized retributive justice system like we have in Nigeria, and I mentioned that earlier. So what are some of the legal frameworks that has enabled restorative justice in Nigeria? Of course, we can't mention legal framework without talking about the Constitution, ACJA that most of our speakers have talked about, then the Nigerian Correctional Service Act 2019, and our Honorable Chairman has said so much about Lagos. Of course, you can't talk about legal reforms in Nigeria without talking about Lagos. So Lagos has been the front runner. So they have a Lagos State Practice Direction on Restorative Justice. However, for the purpose of this talk, I will major basically on the Nigerian Correctional Service Act of 2019. So I will skip the ACJA, which Dr. Yakire has made my job easier once again. Chairman, hope you are preparing my award. Thank you very much. Now I'll go to the Nigerian Correctional Service Act of 2019. Now, it's broken majorly into two parts. So you have the custodial service, which deals majorly about the incarceration and everything. You see that in part 1 from section 9 to 36. Now, of major importance to us is the non-custodial service, which is in part 2, and it's from section 37 to 44 of that particular act. So what is a non-custodial service about? So it makes provisions for parole, it makes provisions for probation, makes provisions for community service, and one thing that the ACJA didn't mention is restorative justice, which is in section 43 of that particular act. And how does restorative justice come into play? It could come into play, some of the platforms you find it in the victim offender mediation. You would also have a family group conferencing, community mediation. These are some of the ways restorative justice comes to play. So the victim is sitting down, or by text messages or by letters, whichever one that is convenient for the parties. I think Dr. Yakire made mention of the fact that it's all about the parties here, right? So both the victim, both the offender will be hugely involved in the restorative justice processes because the victim wants to get a release. And we want to ensure that the offender is contrite about what he has done. And the stages had been mentioned by the earlier speaker. It could be at the pretrial stage, during trial, it could be during imprisonment, and it could even be during post-imprisonment. There is a case of a guy that had been imprisoned. I think it was in UK. But he killed somebody, and then the parents never felt okay, even though the person was in prison, until they sat down with the offender. When they sat down with the offender, they realized the case was actually an accident, right? So they were able to help the offender. So most of the things, people make mistakes, and then they end up in prison, spend a lot of time there. So what are the practical challenges in implementing ROJ in Nigeria? Adequate awareness among the populace and criminal justice institutions on the practice of ROJ. There is no awareness on restorative justice. When I take money from Dr. Yakire and I go to the police, and I don't pay Dr. Yakire back, then Dr. Yakire reports me to the police. The police won't see that it's a civil crime. Their default setting is to arrest me, incarcerate me, and then I will bail myself maybe for 10% of the money I took from Dr. Yakire. Then I will draw up a payment plan. And for each one I pay, Dr. Yakire will pay them a percentage of what I paid back. So that's the default setting in Nigeria. So there's lack of awareness. There's lack of trained personnel in various institutions, quite all right. I was speaking to a judge in Maraba. He told me we talked about probation in the Nigerian Correctional Service Act. But he said there are no probation officers, there are no parole officers even. Right? So even if someone goes on parole, who is the parole officer that is going to monitor them to ensure that they don't commit the crime again? So these things are not there. So lack of political will and proper means to implement the provisions. I think many speakers have made mention of we have very laudable laws in Nigeria. Good laws, wonderful laws, but no political way to implement them because the status quo actually benefits those that are in that system. So no police officer wants to talk about restorative justice when he knows that once he sees Dr. Yakire, money is going to come out from her and money will come out from me. So he eats from both the complainant and he eats from both the victim, which is the victimization she was talking about. Then we have issues of poor funding. Then conclusion and recommendations. How do we make these things better, right? So we will agree, and I believe everybody here agrees that restorative justice is actually the way to go. Now, what are some of the ways we can make it better? There is a dire need to introduce practice directions on restorative justice across the states in Nigeria. Lagos State has set the pace. Other states in Nigeria should also do the same thing. It would actually help restorative justice practitioners in this state. Now, a system that will guarantee the promotion of restorative justice, especially strategies for raising awareness. Now, restorative justice should be taught from 100 level or from our first year in our universities because the problem is that you can't teach a man to be left-handed in old age. From our 100 level in our universities, we already taught about the retributive system. right? Our system, our mind is already in default on the retributive system. Even in the police academies, everywhere, it should be taught from the elementary stages so that we could understand that there is an alternative system to what we have, the retributive system. Just as we have it in the Creed, say there is a grace and there is a law. So you could make your choice which one you want to adopt. Then we should have dedicated training, sensitization, and workshops for key players, just like what we have here today. So, for example, we could have police officers here, and then we are sensitizing them on restorative justice. Now, the effectiveness and accessibility of restorative justice services can influence the criminal justice space when we have procedural laws, access to funding, positive public participation, stakeholders, cooperation, and trust in the process. So that's the end of our presentation. Thank you for listening, and I hope you've been impacted. Mr. Chairman, my award.
Thank you. Well, you didn't win the award. You added 2 minutes more. Thank you very much for your presentation. The presenter dissected the provisions of the Correctional Services Act, particularly as it relates to RJ, and identify some practical challenges. And one of the practical challenges emphasized, and which seemed to have come up earlier, arrest before prima facie case. In Nigeria, that seems to be the approach that we can see. Once a complaint is made, the police arrest. Police should not arrest until there is a prima facie evidence. Because some of those arrests ends up, complicating the process. So I think the police needs to think about that and develop a protocol that you don't just arrest because somebody has made a complaint. And, they also made suggestion, practice that. That's one of that area of suggestion. I think the correct that it will be difficult for you to implement RJ in the states without collaborating with the states. Because most of the states already have RJ institutions in their states. There's no state that does not have a Department of Social Welfare. They have probation officers, they have welfare officers. These are people that will be very useful in implementing RJ. So I think the Correctional Service needs to take that on board, collaborate with states, and fashion out a way of implementing RJ effectively. Thank you very much, Dr. Maduka. Now we are gradually running to the end. We have 2 more. We're going to call Dr. Abdul Rahim Mustafa, Widening the Gap, Interrogating the Exclusion of Female Offenders in Postal Institutions in Nigeria. Thank you very much.
Good afternoon, all. My own way of participating in this conference is a bit different. And how is it different? Yes, we are talking of restorative justice. And this is my paper that says widening the gender gap, interrogating the exclusion of female offenders in postal institutions in Nigeria. Of course, restorative justice, as we are saying, shows that we need restitution, we need reconciliation. And if there's restitution, there's reconciliation, then of course, there will be limit to custodial sentencing. Now, the question is, there are some offenders that still need to be incarcerated. There's no any doubt about that. There are some that it warrants us to put them in custody. Just as, not as punishment this time around, but as a rehabilitation. So my paper here comes from that perspective, that how can we determine this custodial or no custodial sentencing? So my answer is, we need custodial sentencing or custodial institution for some of offenders, especially the young ones. And if we are talking of young ones, then we are talking of both male and female young offenders. How can we rehabilitate them? So in this paper, the outline is copiously in the slide. So let's quickly go to the next. So by way of introduction, I interchangeably use juvenile, young, or child offender in this paper to refer to those children who are in conflict with the law, or children who are beyond parental control, or children who are in need of care and protection. So this kind of children need, in some cases, to be incarcerated for them to be rehabilitated. And in rehabilitation, in this scenario, means that those children should be given therapeutic measure instead of punishment. So I'm not referring to punishment in this scenario, but how they can be integrated into the society as law-abiding citizens. And of course, I know, and you all will agree with me, that there's no any law that is perfect globally. So we need some reformation in our laws. Yes, this paper in the course of examining, I adopted both quantitative and qualitative methodologies. And in adopting these quantitative and qualitative methodologies, I use questionnaire and in-depth interviews as tools in gathering my data to arrive at my logical conclusion. In the methodology, I distributed questionnaires to 4 zones out of the 6 geopolitical zones that we have in this country. And those states are Ogun State, Kaduna State, Kwara State, and Bauchi State. The reason or the justification for picking these 4 states are not far-fetched. The states, Ogun State, Kwara, and Kaduna, have all the 3 booster institutions in Nigeria. So that's one of the justification of venturing into those states to examine, to verify my questions. And of course, in these 3 states, they all have domesticated the Child Rights Act and the Administration of Criminal Justice Act. But in Bauchi State, Bauchi has domesticated ACJA, but they are yet to domesticate Child Rights Act, to show that Bauchi State is still using the old colonial Children and Young Persons Law of 1946. So, in that wise, Bauchi State used juvenile court instead of a family court. So I examine all these states in order to buttress my position. And in examining these questionnaires, I distributed the questionnaires to 400 respondents, but at the end of the day, 300 respondents returned the field questionnaire after putting into consideration the ethical approval from my university in order to venture into the field work. Of course, I have some limitation in respect of this paper, and of course, the limitations include finance and space. There's not much time. Otherwise, I could have gone to other states to see what is happening there. So to show that my analysis may not be generalized to all the states in Nigeria, especially those states that are yet to domesticate ACJA and Child Rights Act. But I believe that rigorous exercise has been inputted in this paper in order to translate the data. Slide. Yes, in this paper as well, I examined the legal framework for the operation of booster institutions in Nigeria. And I came to realize that booster institution in Nigeria gained credence or its legitimacy from Section 35, Sub 1D of the 1999 Constitution as amended. Of course, that constitution, that subsection stipulates that every person has rights to liberty, but there's some exception to that exercise of liberty. And those that proviso affect those children that are less than 18 years that need education and welfare. And that is more reason why Booster Institution was established in order to give education and welfare of those children that are in conflict with the law, beyond parental control, or in need of care and protection. And again, apart from the Constitution, we have the Booster Institutions and Remand Centers Act, enacted in 2004. And of course, we have a laudable one of the Nigerian Correctional Services Act of 2019. But in reality, or in practice, what we are using in Nigeria practically is that Booster Institutions and Remand Centers Act of 2004. So, Nigerian situation, we are yet to implement the laudable provision in ACJA. Because in ACJA, it provides that there must be room for both male and female young offenders. But in this wise, the reverse is the case. Practically, we don't have Booster girls. We only have Booster boys in Nigeria. I can't imagine. In olden days, yes, we believe that the young offender, or the female generally, or female, are mostly victims of crimes. But in this present situation, we have a lot of cases whereby young female offenders are now committing capital offenses in Nigeria. So where are we going to put them if there is need for them to be incarcerated? So the question is, where are we going to put these young female offenders when we don't have a Booster girls? And of course, the correctional services or prison or correctional services that we have today, or prison or correctional centers we have today, the remand homes we have today, the government-approved school we have today are not effective at all in rehabilitating these young offenders. The only custodial institution that is a bit effective in rehabilitating young offenders is this Booster training institution, because they have both educational and vocational trainings. But prison, correctional centers, remand homes, government-approved institution has nothing to offer young offenders of today. So the question now is, how can we say that we have Booster boys, no Booster girls, when the law is very explicit? In Section 3 of the Booster Institutions and Remand Center Act provides for offenders, and that offender is supposed to be both male and female. But in practice, we have only male, no female, no provision for female in Booster institutions. And of course, we need to consider as well Section 3(1) of the Booster Institution and Remand Center Act, which stipulates that remand homes is just for passage, temporary passage for juveniles. So to show that there's nothing to gain in those institutions other than for juveniles to become hardened criminals or rotting without being reintegrated into the society. This slide shows the commission of crimes by female juveniles, young female juveniles. And you can see that young female offenders make up of 10% of population of prisoners in the correctional institution, where adults are confined. Okay. So next slide then. So the figure here shows the percentage of the respondents that says Booster institution is more preferable than other custodial institutions for young offenders. Next slide. Next slide. Okay. So
just go to recommendations so that we can move on.
Okay, go to my table 4, table 5. all shows the the confirmation, reaffirmation that yes, we need booster institution for young female offenders in Nigeria in order to have a very egalitarian, crime-free society. So my recommendation now, yes, I recommended that the prison booster training institutions and remand centers acts need to be amended to include specifically female or young female offenders to show that the masculinity in the interpretation of the word offenders or his in the act is being interpreted that the booster is for boys. It should include young female offenders as well. And of course, I said, yes, we know based on the questionnaire at the interview administered, some respondents said booster institutions is a bit effective. Yes, they want funding too, so it needs to be funded. So I'm very grateful and thank you for being attentive.
Thank you very much. I mean, it's actually a shame that we didn't have enough time to listen to this because this is yes, you can go and have your seat. This is one area that a lot still has to be done. Even in our Lagos that we are supposed to be the leading, a lot still has to be done. But it's a tragedy. You have a country like Nigeria, they will say there's no fund. When you be spending up close to 4 trillion naira on fuel subsidy that everybody knows is a scam. It's a scam. You know, and the government will be telling us they are fighting corruption. Which corruption are you fighting? You are funding corruption. 4 trillion naira to fund fuel subsidy. You know? As far as I'm concerned, it's funding corruption. You now say no money for education. No money to take care of, child offenders. No money to rehabilitate them. No money for health. But there's 4 trillion naira, 3 trillion naira plus to fund corruption and steal it. I don't want to go there. Let's just go on. Let's just go. Because you see, many of these institutions are clearly not funded. Even in Lagos. Many of these institutions are, the priority that we should put on these things is not there. But we say there's no money, but you and I know there's money. Now we have money now to reprint 1,500 naira notes. When we should actually phase them out of existence. Because you don't need them any longer. I've been to America many times. I've never seen a $200 bill. And it's still a legal tender. So, don't let me be despondent like that young man. There is hope. So let's go to the last presentation. The rights of victims in the criminal justice process. How real? Dr. Abila Adzad and Awele Ikobi. So if you choose to take it 5 minutes, okay, go ahead.
Good afternoon, everyone. So our topic is on the rights of victims of violent crimes in criminal justice process. That they actually exist. This paper was written and is going to be presented by my colleague and I. So it's divided into 2 parts. I'll take the first part while he takes the part. The next slide, please. Have the introduction, definition of terms, victimology theory, rights of victims, legal framework. We'll be examining Nigeria and Ghana, then conclusion and recommendation. Next slide, because we talked about who is a victim of crime. I don't need to mention this again because Dr. Oyakire has already mentioned, but I will just add to what she said that the person may be considered a victim regardless of whether the perpetrator is identified, apprehended, prosecuted or convicted, irrespective of familiar relationship that the person may have. For example, daughter-father relationship, husband and wife relationship. Say because so is my husband, is my wife, and all of that, that I'm not a victim. No, so I'll just add to that. So going forward, I will just go to the victimology theory because most of the things that we said in our paper has already been mentioned and presented by Dr. Sisi. So we'll just look at the victimology theories. So victimology studies to understand the crime from the victim's perspective. We are talking about the victim, but the victim who has or is suffering from any injury or destruction due to some other individual's group or individual's action. So it has been discovered that the role of the victim is very important and significant, as it can directly or indirectly influence the fate of the victim and also motivate a criminal. And the proponents of these theories, Marvin Wolfgang and Benjamin Mendelsohn, they said there are 4 theories. So we'll just look at the first one, the victim perception theory. What does the victim perception theory say? It says that crime victims attract victimization to themselves by their provocative and instigatory behavior during interactions between perpetrators and their victims. For example, while we are talking about violent offenses, offenses such as rape will be caused by the action of the victim, or for instance, when a person leaves his or her door open and an intruder comes in and steals property, it could be said that it is the fault of the victim. But having looked in our paper, we established the fact that having looked at contemporary times and how criminal justice and criminal justice administration have progressed over time, I don't think it's quite popular to say that the action of the victim will lead to the crime itself. So from this perspective, I don't think in contemporary times many of these theories can come into play. So let's look at the second one. Third example, for example, when you come to issues of assault, when I was practicing then in Asaba Delta State, we come to court for criminal matters. You just see one person say, he came to meet me, I just pushed him and he fell and he died. Such issues occur every day in court. So we look at it. So the victim precipitation theory states that most times victims are the people that make themselves susceptible to crime. Then look at the lifestyle theory. This theory believes that those whose lifestyle increases criminal exposure are more likely to become victims of crimes. Thus, people who engage in their daily activities may be in contact with those people by their daily lifestyle. For example, if you ride expensive cars or you display expensive phones, you're walking on the street, you display your recent iPhone 14 Pro Max and all of that. This theory says that you can draw attention of the defendant to yourself. But like we said in the paper, we do not also agree with this theory. Looking at Nigeria, for instance, we know kidnapping is rampant. And these days, they even kidnap people who do not have money. So you can see that this lifestyle theory, to an extent, has failed. Also, we look at the deviant place theory. A deviant place theory takes a different approach as it shifts the blame from the individual victim, but shift it to the location where he or she visits. Also, when you look deeply into our paper and into this theory, you also find that this theory will also fail. Why? Because most of these violent crimes that occur is not because, I visit a particular place always. That's why maybe somebody, I close at night. It may contribute to it, but not necessarily absolve the offender or shift the blame to the victim. You won't say because a young girl closes at night, that's why she was raped. If you talk about that, what about children who are defied and all of that? So from our paper, we said that these theories are no longer fashionable at this time, though these theories were first proposed in the 1940s and all of that, but it has also helped to develop criminal justice and criminal law. So we look at the routine activities, which is also similar to the lifestyle activity theory, as both emphasize how patterns of routine activities or lifestyle in conventional society provide an opportunity structure for the crime. Having said that, the victimology theory, to an extent, has helped in developing criminal justice, and it's established that although these people are victims, they can contribute to, their activities can contribute to crime. But what we are saying in our paper is that it is no longer fashionable, and in contemporary times, looking at the provision of the criminal that said that you must prove beyond reasonable doubt. So if you are pushing the blame on the victim, I don't think it serves any purpose, because we're talking about the rights of victims. So at this point, I will just cede the microphone to my colleague who will expand more on the rights of victims under the established laws. Thank you.
That's exactly 5 minutes. So 5 minutes more.
One of the benefits of speaking last is that what you ought to have said will have been said by everybody. Simply come to adopt what they have said. That is why I'm here to adopt what all have said. And then just to add a little, now in our adversarial system of justice, yeah, offenses, crime is considered as offense. That is why we find that level of investigation, trial, the state on everything, very minimal or little on victim of crime. And discover that in our constitution, like the constitution of many other countries, the fundamental rights that are contained therein appear to more interested in protecting the rights the offender. That is why you find such rights as offender has a right to be fair trial, has a right to be brought to court within a reasonable time, and so on and so forth. So little emphasis is placed on the rights of the victims. And that brings to mind the question whether victim matters at all. And you discover that where the victim feels that his rights do not matter, it leads to more provocation on the part of the victim. I am the person that is aggrieved. I am the person that suffered losses or injury. And yet, protection is given to the person who perpetrated crime against me. And it leads to a lot of issues. In our criminal code, there are provisions which appear to take the interest of victim. For instance, the provision on payment of compensation, the penal code. But these are not. And right of victim goes much beyond payment of. There are so many other rights that a victim damages. And under international law jurisprudence, discover that issues of common crime or petty crime, small crime, are left to domestic legislation to take care of. So a lot has to be done by national government to protect the rights of victims. In Nigeria, there has been a shift recently with the enactment of the Administration of Justice, whereby the rights of victims are now being more attention. And I'll look at a few times under the administration. There are a variety of rights which appear to be in tandem. United Nations General Assembly Resolution 4034, which recognizes a lot of rights that should be given to victims of crime, like access to justice, right to compensation, restitution, damages, right to the protection of the crime, and so many rights under resolution. So I believe that the Administration of Criminal Justice and the BAP Act appear to take into consideration some of these rights that have been recognized under the United Nations. So under the Administration of Criminal Justice, we have a variety of rights which are credible to crime. For instance, a victim is entitled to expeditious determination of justice, what is called a closure. And that is why under the ACJA, find provision of day-to-day trial, which is highly commendable. But one of the problems I have with that is whether or not it is practical. All know that this is view of the infrastructure, manpower that we have in this is basically impracticable. We have day-to-day. I've been doing a matter in court, started in 2015, and it took 4 years to take one witness. 4 years to take one witness. Out of these 4 years, 2 years was spent on trial within trial. So it becomes very, very difficult for us to have this day. When the judge is adjourning the matter, 3 months or thereabout. So we have problem with it. Although the act itself recognizes the impracticability and therefore gives some measure of leverage, 5 adjournments party, because that is also problematic because after the exhaustion of the 5 adjournments, when the trial is not concluded, what next? It makes another provision for 2 additional adjournments, but it didn't state as whose instance. So we have a lot of problems with that. It also contains a lot of provisions on restitution, compensation, and damages that should be paid to the victim of offense. And one of the problems I have with some of the provision damages, a provision says that that in the course of trial, judge can order defendant pay compensation. And I ask, view of the provision, constitutional provision, presumption of, how is it possible for judge to order a defendant to pay compensation when he has not yet been found guilty? Does it not violate that right of presumption of innocence? That's a subject for other time. Then we have the Violence Against Persons Act, which to me, the more comprehensive legislation when it comes to protection of the rights of crime, because it contains a lot of provisions that appear to give protection to victims. Not be a perfect legislation, but it contains a lot of provision. For instance, right to assistance, right to medical care, and so on and so forth. So many rights that are contained under the VAP Act. If we find time, because of time, may not be. But these rights are contained. Now, I must also mention that we looked at the legislation in Ghana, legislation in Ghana, which appeared to be very similar to our VAP Act, that's the Domestic Violence Act, Ghana, which came about as a result of agitation by civil society groups, human rights groups, and so forth, and led to the enactment of this Ghana, which also contains provisions that are very, very similar to what is of VAP Act. But in the whole all of this, we looked at, is it possible for us to have a perfect system? I would say no, because of the peculiar circumstances of the environment. Here we have infrastructure deficit. Here we have manpower deficit. A lot of things that will make the implementation of these very robust provisions impracticable. And we concluded by saying that, making some, particularly in Nigeria, we recommended that the victim support fund, very, very serious attention. Ghana, they have victim support. Just, also call on governments to for now. And lastly, I conclude. My colleague here asked me, why did we choose Ghana as a basis for this presentation alongside Nigeria? And I said I was going to say it here. Chose Ghana because we are discussing rights of victims. And we chose Ghana because Nigeria has been a victim of Ghana. We had boasted that going to the World Cup is our right. They came here, violated this right, and took away that ticket. So we know that we are their victims. And they should know that we have a right to compensation, to restitution, and to damages. Thank you very much.
Thank you very much. I like that. The only problem here is that they've not constituted any wrong or injury to you that is known by law. Yes, we want to thank the team from NIALS for their presentation. They looked at various theories explaining victimology. And then the second speaker actually emphasized the fact that our criminal justice system places so much premium on the rights of the victim. That's true. Now the emphasis should shift towards protecting the victims of crime, and I mean, for short of better words, developing a victim's bill of rights, ensuring that we provide for all the rights that victims should have in our laws. And some of them are already in our law. And you refer to the issue of the law providing for compensation, damages, and all that. And how is that to be done? It's my view that should be part of the responsibility of the prosecution. It is the prosecution that should lead evidence. After having led evidence to sustain conviction, they should lead evidence to establish the basis for the compensation, because the court is not the Father Christmas. If there is evidence before the court as to the loss that the victim has suffered as a result of the crime, then the court will be able to award compensation. Now the law says you can award compensation. So the prosecution can take up that as part of its responsibility. The prosecution should protect and advance the rights of victims of crime. So that's a possibility as to how that can be done, so that the victim does not have to now subsequently file a fresh action for compensation. That claim for compensation or damages can be taken together in the criminal proceedings, so long as there is evidence before the court to that effect. Thank you very much. Now, I've been directed by the organizers that we should only take 2 questions. 2 questions only. Okay? All right. So, one here, then I saw the hand of the lady at the back after the gentleman in the front. Yes. I've been directed. You know, in the ministry, once you are directed to do something, that
Thank you, moderator. And this is a problem when we eat too much time and then we have nothing to spare. Now, my question goes to Dr. Abdurrahim. Whereas many progressive constitutions in the world and various conventions and treaties which have been ratified by many progressive states have affirmed the need not to institutionalize young persons, and Boston institutions is one such institution that has been categorized as penal institutions. Whereas those good instruments speak against institutionalization unless it is as a last resort and for the shortest time possible. Have you done any research to get the findings of the progressive outcomes of the programs in the Boston institutions you currently have that would agitate for your case to establish institutions for female Boston, for girls to attend to Boston programs, whereas we know universally that the fair gender contributes significantly low to the effect of overcrowding in our prisons comparatively. That is my case. And who holds brief for victims in this country? Is it, because I know prosecution holds brief for what do you call the state and complainants. They hold brief for the state and complainants and not victims. Who holds briefs for victims in this case that will advance their case? Thank you so much.
Good afternoon. I am Mima Abasudowima. My question is actually an outflow from his holding brief for victims. It's actually more of a comment because I have noticed in Nigerian litigation system that if a person goes to court and says he's holding watching brief for the victim, court would say, I do not see you. You can only be seen but not. And watching brief is when a victim hires the services of a lawyer to protect his interests in court. Now, the time I was holding watching brief for a bank that was the victim of a cybercrime case. And this bank had lost millions of naira to a cybercrime. And when I went to court, the prosecution was not the court was about to strike out the matter, and I stood up quickly. Hey, Lord, I'm holding watching brief. The court said, can't be heard. And then the matter was struck out eventually because of that. I would also like to mention that the issue of watching brief, if a lawyer holding watching brief could step in place of the prosecution counsel.
Although I had said to, I will use my discretion to allow the correctional service officer to ask his question, because a lot of the things that we've said in this session relates to correction. So, sir, quickly, a quick short one.
Thank you, Chairman.
Yes, sir.
Thank you. First of all, let me talk one or two things. To Mustafa, your worries about female postal institution, I think it has been taken care of by the Nigerian Correctional Service Act 2019, Section 35 particularly, made it mandatory that every state in Nigeria will have a separate postal institution for male young offenders and another one for female. The issue is that it has not been actually implemented. So that is
Sir,
one.
did the law say who is going to fund that Bosa institution? It just says
the Nigerian
that
Correctional Service, according to the Act.
Oh, who fund it?
But the state can also, because most of the inmates are from the state.
They cannot sit down in Abuja and be making laws that will have financial application for state.
So for now, the law said, the Section 35 of the Nigerian Constitution. Also, another thing again I want us to understand is that...
quickly, sir, very quickly.
Yes, sir. There is also a kind of lack of willingness. We are appealing to the judiciary to assist us. Like the restorative justice you are talking about. Most of the time, it's the act too, but it has to be activated by a judicial process. You cannot just sit down and at the Consolidating Center and said, we are doing restorative justice. So this is lack of willingness, or I don't know. I'm sorry that I don't be committed to imprisonment. But they did not,
sir, the point is understood, sir. But you also need to take away one point. If you do not have the institutions and the arrangement to facilitate RJ, the court will not make any referral.
Let me just finally, before I sit down. About somebody is talking about staff. There is no staff in non-custodial. It's not true. The Nigerian Correctional Service had trained more than 3,500 staff posted in all the states in Nigeria, including Lagos.
Okay, sir.
In all aspects of non-custodial, including parole, probation, restorative justice.
Thank you very much,
I'm
sir.
now using this opportunity to inform you that in your state, go to any decent and activate the non-custodial aspect. Staff are there, trained, qualified, eminently.
Okay, sir. So, Doctor, there was a question for you. So, very quickly, 1 minute.
Thank you, sir. I think 2 questions were thrown to me. Yes, I quite agree with the learned professor from Kenya that yes, there is non-institutional provisions now that the offender should not be institutionalized. But from the paper I presented, I said we cannot do away totally without rehabilitating some offenders. And if we are to rehabilitate them, then we need custodial institution. Here we are talking of young offenders. Young offenders in this wise means those children that their best interest is to incarcerate them. So Section 1 of the Child Rights Act said the best interest of the children must be put into consideration in any action related to children. So if the best interest of that child is to put that child into custody, then so be it. The only thing is that we need to put all things, infrastructure into places to rehabilitate that child. But in this, second one, yes. In this wise, to rehabilitate young offenders, I don't say it's to be a punishment, but to be a therapeutic measures in order to integrate that child into society as law-abiding person. Then secondly, to the controller of prisons. Yes, I know the law is there, Section 35 of Nigerian Correctional Services Act of 2019, but it's not implemented. Presently, we are still using the Bosta Institution and Remand Home Centers Act of 2004. And that is more reason why we don't have Bosta Institution for female up to today. 2019, the law was being promulgated, and we are 2022, going to 2023, and there's no any steps so far to establish Bosta girls.
There's a quick one on complaints. 1 minute.
Thank you. Both questions actually talk about, and it speaks to the issue of participation. Victims are not participating in the process. Then, so we just have the laws, actually. One of the arguments in my paper. This law, complainant, the victim, in most cases, is the complainant. And if you look at the definition of who a victim is, the person who has suffered harm. At times, is a faceless victim, but somebody has suffered harm, and where you find the person physically, the person is the complainant. And fortunately, practice, the nature of our adversarial system, states encompasses the rights of the...
Thank you very much. all the presenters and also all the audience. And we apologize for having to hurry the interactive part. I think in order to further save time, we can just go out and take our group picture outside while the coordinators can go on with the next session, so that we don't use that to take an additional 3 or 4 minutes. So the members of the panel will go out, they will take a picture in front, and then you can continue. Thank you very much,
Mr. Chairman, for that wonderful consideration. And we sincerely appreciate you and members of the panel for this wonderful session. Thank you so much. Without much ado, we progress to the next session, which is the third working session for today. And it is on effective mechanism for the management of pretrial detention in sub-Saharan Africa. And the chair of this session is no less a person than Professor Isabella Okagwe, Fellow, Nigerian Institute of Advanced Legal Studies. May I have the pleasure and honor to invite her to grace the high table. You are welcome, ma'am. Joining learned professor on the high table is Dr. Dennis Bikesha, Dean, School of Law, University of Rwanda. You are welcome. Thank you very much, sir. I have the privilege also of inviting Jamin Tawiyamara from Ministry of Justice, Burundi, to join them on the high table. We have Mr. Jamin around. Okay.
I'm following
joining
through the
virtually.
Zoom.
Okay, thank you very much. We are happy to have you joining us.
Thank you.
I also invite Mr. Francis Enobore, Controller Retired of the Nigerian Correctional Service, to join them on the high table. You are welcome, sir. To follow quickly is DCP Simon Lowe, Senior Advocate of Nigeria. You are welcome, sir. The convener of Duty Solicitors Network, Mr. Bayo Akinlade, please kindly join us on the high table. I also have the honor and privilege to invite Oluwafunke Adeoye to come to join the panel. Last but not the least is Mr. Clement Okech from Kenya. Kindly join the panel, please. He has been here, possibly he stepped out. I believe he will join us soon. Thank you very much, Mr. Chairman. The panel starts now.
Hello? Okay. Thank you very much. This is the third and last working session for today. And the topic is effective management of pretrial detention in sub-Saharan Africa. I'll very briefly set the context for this. I won't take too much time because it's a long session with plenty of speakers. Now, and this context is mainly for the benefit of non-Nigerians in our audience who may not be familiar with pretrial detention in Nigeria. Now, basically, the prison system in Nigeria is antiquated, dilapidated, and overcrowded. In some cases, the prisons contain inmates in 200%, in excess of 200% or 300% of their original capacity. And almost 70% of the inmate population are persons who are awaiting trial. And these persons spend days, weeks, months, years in detention. Sometimes they spend longer in detention awaiting trial than the possible sentence for the offense for which they are detained. Now, we all know the pernicious effects of pretrial detention, especially extended pretrial detention. It's a violation of the rights of the prisoners, a violation of the presumption of innocence. It means are stretched, overstretched, and resources that could have been devoted to rehabilitation programs for those who are convicted cannot be used for that purpose because they have to be stretched to accommodate the ever-increasing number of persons awaiting trial. It has implications for the health and safety of inmates. Communicable diseases abound. Overcrowded can lead to prison riots and prison breaks, of which there have been an increasing number in Nigeria in recent years. And then it also leads to, it breeds resentment and dissatisfaction in the persons who are caught up in this spiral, and they become alienated from society, and that alienation in turn poses a potential for more criminality on their part. Now, this has been a long-standing problem. I've been attending conferences for 40 years, I would say, at which this problem has been identified, debated, addressed, recommendations have been made, and yet here we are, I'm now retired, and we're still discussing issues that I first came across when I was a young graduate assistant immediately after youth service, when I joined the Nigerian Institute of Advanced Legal Studies. Now, the ACTA has introduced various recommendations and solutions to address the problem. I'm excited to listen to the members of this August panel discuss what they see to be the solutions and how ACTA has improved the situation. I'm also excited by the fact that we have our brothers and sisters from other African countries to tell us about what is going on in their jurisdictions and how they have solved these issues. So I'm eager to listen to them and listen to their recommendations and advice and solutions that they have to proffer. Now, we have 7 papers listed for this session. I'm not going to read out the names of the papers and the presenters. It's in your program. But I would like to add that we actually have an 8th paper that is not listed on the program, which will be delivered virtually by Mr. Babatunde Akinonju, who is the founder of the Criminal Justice Advisory Group, and he will be speaking also on the 3rd topic on the list. So we have 2 speakers for that topic. Now, unfortunately, this is the last session before lunch, and I'm sure people are pretty hungry at this point. I'm going to be very strict with timekeeping. Each person has 10 minutes to make their presentation so that we allow for a few minutes of interactive participation with the audience at the end. So I would, I've also been told that there's a lady delivering the lecture on leveraging technology as a tool for reducing pretrial detention in Africa, lessons from Kenya. This is going to be delivered by Funke Adeoye. She has requested that she be allowed to deliver her paper first because she has another engagement. Not so? You're okay. Oh, okay. Well, that's what the organizers told me. So you're happy to take your paper as and when. Okay. All right. So the first paper then will be Effective Mechanisms for the Management of Pretrial Detention in Sub-Saharan Africa, which will be delivered by Dr. Dennis Bikesha, Dean, School of Law, University of Rwanda. You're welcome, sir. Over to you.
Thank you, moderator. Thank you, the organizers and the audience at large. It's my pleasure to say something about effective mechanisms for management of pretrial detention in sub-Saharan Africa, but I will be talking about Rwanda because that is where I have gathered more information. being my country and having also my presence in Rwanda, the School of Law, that is what I can share most. Second, I have an introduction which may begin with the definition of pre-trial detention, but that is very easy because that is defined as the period a person may spend in a detention facility, and this person is accused of having committed a crime. And I have to mention that in our African and sub-Saharan Africa, to be particular, our detention facilities are not the best, and therefore we get a lot of hardships when we are there. This is something that has to be a last resort, not something that has to be, it's not enjoyable, therefore there has to be, make sure that it's not done, because the principle is not to be detained when accused. But among the repercussions that we see, the fact that someone is removed from his or her family, that is a very hard thing, especially when you are even the winner of bread of your family. But also it infringes with the right of presumption of innocence, especially when press is involved and you are a public figure. There is something that you cannot inform the community that you are innocent when otherwise like the authorities are referring to you as a criminal suspect and sometimes referring to you as a criminal. But there are also other things that may be mental and even psychological. Next. One of the principles that should be emphasized in this presentation is the principle of habeas corpus, which means that at any time I feel my freedom is tampered with, I should get the opportunity to go to the authorities, especially the judiciary, and then I launch my case. And this is a principle that has been in place for many years because it is even part of the Magna Carta, or one of the documents that UK has been using instead of using, they don't have a codified constitution since 1215. And it is related also to another principle of habeas corpus related, which is interdicto de hoc libero exhibiendo, which is also related to that you have to make sure that when you approach the judiciary, they have to assist you. The discussions we have about detention are not the first ones. I have been looking at, for example, discussions that took place in 2004 at Lilongwe in Malawi, where through these discussions, governments were advised to introduce some measures in prison that may be helpful to people who are in criminal, who are detained. These measures, I would say, they are, for example, informing the magistrates that they should screen the remand caseload on a particular basis. Maybe this is related to seeing how these people are treated, but also how much time they have spent in the remand. If it is not lawful, then they can release the persons. But also the aim to make sure that the people are remanded lawfully itself is an advice, and their cases also are being expedited, and that the criminal suspects are held appropriately. These are some of the advices that were given during that meeting in Lilongwe. And we are talking about adherence of countries. Do we have countries that adhere to such situations that are related to the advice that is given? Sometimes this is not the case, but when it is not the case, what should be done? what should be done is that these state agents should be challenged. We have, for example, regional courts such as the African Court on Human and People's Rights that receives the individual's complaints, but on condition that these complaints should have been presented to the domestic courts. That is the condition. Next. We are looking at effective mechanisms, but because of the story you know about Rwanda, we have to make sure that we look at Rwanda in the aftermath of the genocide, where over 1 million people were killed, and that means even according to the cases that were in place, even 1 million people must have participated. I worked for the Gacaca courts that were dealing with genocide cases for 8 years. I know how the cases have been and the numbers. It was something that was really challenging. But also when you look at how the genocide was perpetrated, using machetes, so everyone getting a machete and go to what they called to work, and also the involvement of the people, the Hutu militia, like the Interahamwe, was close to 1 million. So you can imagine the question was, should we detain 1 million people in the aftermath of the genocide? That was an alarming situation. But the good news is that not 1 million people were detained. When the Gacaca courts started, it was only 120,000 people that were in prisons. And as I speak, probably I would have to mention it somewhere else, but as I speak, we don't have even 25,000 people out of the 1 million people that are in detention facilities. And that is even after being, the case being had. We can see the period of time, which is only 100 days in which the over 1 million people were killed. Next. Among the solutions was to look for alternative ways and not using the classical ways of hearing cases. And that is where you find Gacaca courts coming in. And the Gacaca courts were to speed up the cases, one of the reasons why they were created, and to make sure that also the population participates closely, where you find that everyone, every adult had to participate in the genocide, to resolve genocide impact through the Gacaca courts. Next. That is a picture I usually show when you want to see how Gacaca court setting is. People in the colors of the national flag are the judges who are not legal experts, but a peer population that is taking lead to hearing cases, and then people sitting or standing on grass, which is the etymology of the Gacaca's word, because Gacaca means grass, and that is how the courts, over 15,000 benches were sitting to resolve this problem. Next. So we look at Gacaca having its temporal jurisdiction from October 1st, 1990, which is different from the ICTR for those who have followed, because ICTR considers 1st January 1994 to 31st December 1994, just one year strictly. But we also see that to make sure that we don't detain very many people in Rwanda, for example, some crimes, even if they are genocide crimes, like property-related cases, were not supposed to be prosecuted by the courts, but even restitution was the only thing to be done, and there was no punishment other than restitution. So that means there wasn't even supposed to be detention. During this time that the courts were working, I remember the story I wanted to share if time was there, because the boss of International Committee of Red Cross came to my office and said, unless we get a solution, I'm not going to move out of your office. So that triggered because there was a number that was hiking during the time Gacaca courts were trying cases, and we had to see it. I sat with that boss on behalf of the Secretary General of the National Service of Gacaca Courts, who had delegated me. And in 2005, we had the law on Gacaca Courts to be amended so that we can have detention not as much as possible. And then we also had in 2005, the president had to make sure that instructed the authorities to release those who were young during the commission of the crimes, those who were older, and even the sick. So those got out, not to say that it was pardoned, but to be prosecuted when they were outside the prison facilities. Next, I need to rush so that I use the time. So we go to effective mechanisms during ordinary time of crimes, not genocide. The first one is what has been mentioned by many. In Rwanda now there is a campaign that is going on. Since the criminal procedure code we have is of 2019, but now in 2022 is when we have a campaign to make sure that the articles that are in the criminal code, articles 26 and 27, should be implemented. But because also there isn't enough information on how these articles of plea-bargaining can be implemented, then there has been instructions by the Prosecutor General that were signed in July to make sure that implementation is possible. But again, without the knowledge that is in place about plea-bargaining, then this is why there is a collaboration between Pepperdine University in California that have now come with 7 team members that are helping people to see and understand plea-bargaining, and there is a pilot in 5 districts that I have mentioned. Next. The other thing that is maybe, let me summarize it. The other thing that is maybe not in your country is fine without trial. That is part of the criminal procedure also. Someone that is being accused may just be asked to pay a fine and will not go to court. And that one also prevents someone from going to prison or from being detained. Next. The other thing is bail, which is also part of the criminal procedure of Rwanda in Article 81. And this means that you can give some money, and this is also related to a situation where the court has to look for you have to look for someone to present to the court, so it is double. You can get someone as a person or you can use money. Next. Then there is also alternative dispute resolution. With the introduction of Gacaca courts and their success, even the Constitution of Rwanda has included homegrown solutions in Article 11 to be part of the ways that people can use as to resolve problems, including problems in the justice system. There is mediation. Next. Then there is promotion of this principle I have mentioned, the habeas corpus, and and also there is the crime prevention and technology. The technology also, not maybe as explained by the by the presenter who talked about artificial intelligence, but here in our procedure in Rwanda, it shows that you can get like a gadget, then it is taken by you and they are monitoring you other than putting you in prison custody. And this helped. I gave the example of what worked during COVID. People were asked to keep in one place and they were monitored by use of that technology with the gadget that they had. I thank you so much.
Thank you very much. Yes, so you've made a microphone available for speakers. Thank you very much. You did exceed your time, though, but it was very interesting. You've reminded us of the principles of habeas corpus, and then the different mechanisms adopted in Rwanda, both in relation to the genocide, criminal trials, and in the regular courts. And some of your suggestions I found quite interesting. For instance, the fine without trial. I'd be interested maybe later to know how that differs from plea bargaining, where the agreement is for payment of a fine, how that differs from fine without trial. And then the use of technology in crime prevention, the tagging of suspects so that they can be released on bail and you have the assurance that you can find them later. So thank you very much. I'm sure you'll have a lot of questions from the floor. So next I'll call on Jermaine Ntawuyamara. Sorry, I've massacred that name. Who is going to, this is a virtual presentation. Organizers, are we ready for this? She's going to talk, he's going to talk about the management of pretrial detention, challenges in protecting the fundamental human rights of suspects and defendants in Burundi. Okay, go ahead, you have 10 minutes.
Morning, everyone, as all protocol observed. Germain Ntawuyamara. I'm a director responsible for civil, criminal, and special affairs in the Ministry of Justice, Burundi. I want to share with you the management of pretrial detention, challenges in protecting the fundamental human rights of suspects, defendants, and in Burundi. So first of all, I want to present you Burundi. Next, I want to present you Burundi. Burundi was colonized by Germany and also by Belgium. Burundi is located between the Republic Democratic of Congo, Rwanda, and the United Republic of Tanzania. And in Burundi, we speak French, English, and Swahili. I want to introduce the human rights are inherent to every individual as a human being. The fundamental human rights start to be managed at the trial detention. The mechanisms in Burundi have been put together to make sure that the judicial decision, practical guidelines, strategies are respected. So the main legal framework in Burundi, we have the Constitution of the Republic of Burundi. We have the law amending the Code of Criminal Procedure. We have the law revising the prison system. And also have the ministerial order on the internal regulations on prison establishment. So what is the right incorporated in the Burundi Constitution? We have the right that every person to life and physical integrity. There is a right not to be subjected to torture or cruel, inhuman, and degrading treatment. We have the right to respect for human dignity, the right to privacy, and so on, including the right to appeal, the right to health. So the rights of suspect before the police and the prosecutor office. Any person arrested in Burundi must be recorded in appropriate register, which includes the complete identification of the person, the date of arrest, the reasons for the arrest, the place of arrest, the status of the person, the identity of judicial authority who made the arrest, etc. So the suspect has the right, and is saying that every person who is arrested has the right to certain necessary information. In the event of prosecution, each person has the right to choose a counsel to communicate freely with him in complete confidentiality, to be assisted by his counsel during the act of investigation, the right to remain silent in absence of his counsel. The suspect has also the right to be assisted in legal aid at pre-trial. In the Ministry of Justice, we provide until he's convicted by a judge. Now I want to talk to you about the pre-trial case management.
Hitch, what do you advise that we do? Will we try and reconnect with him later? Okay, so maybe...
I'm back.
Are you back? But we can't see you.
Yes, sorry. I don't know what's happening.
So we'll see whether we can come back to the speaker.
Is it okay now?
Oh, he's back. Oh, you're back. Sorry, we seem to be experiencing some technical hitches.
Yeah.
But please go ahead and let's hope you can get to the end of your presentation.
Okay, I'll say that's in pre-trial case management. When a crime is committed, the primary investigation is carried out by the police. When the police exhausts his investigation, he submits the case to the public prosecutor for further inquiry and follow-up. The public prosecutor has power to continue the case and close it, or to institute legal proceedings against the offender who becomes the accused before the court. So what is the criminal case management at the court? Suspects has right to be presented by the prosecutor before a judge before 14 days to decide the detentions. The decision is available within 72 hours. The suspect has a right to appeal against the first judge's decision. The appeal decision is available within 72 hours. So what is the definition of preventive detention? Freedom being the rule and detention the exception, the accused can only be remanded in custody if there is sufficient evidence of guilty against him and facts with which he is charged seem constitute an offense punishable by law with a penalty of at least 1 year of penal servitude. So what is the condition for the preventive detention? Is to preserve evidence or prevent either pressure on witness or victims or fraudulent consultation between the accused, co-perpetrators, or complices. To preserve public order from the current disturbance caused by the offense. Put an end to the infringement or prevent its renewal. Guarantee that the accused remain at the disposal of justice. The decision to maintain preventive detention must be duly substantiated. So what is the bail? In all cases where detention is authorized or extended to satisfy the condition of Article 154 para 2, the judge may, if the accused so requests, order that he nevertheless be released provisionally on condition that a sum of money is deposited with the registrar as a security. So we have two kinds of bail in a court. There's a bail without paying money. A person arrested may be released on a specific condition determined by law. There is also a bail by paying money. When a person is brought before the court, he or she may be released on a bail and the amount is fixed by the court. No specific act on bail. The court is independent to fix the amount. The bail as a guarantee. The bail guarantees the representation of the accused in all the acts of the procedure and the execution by him of the custodial sentences as soon as it is required, if necessary, the repair of the damage caused by the offense, the payment of fine, and the court cost. So we have also the exception to the rule on bail. The provisions of the proceeding article do not apply to persons prosecuted for a crime punishable by more than 20 years or penal servitude, to persons who have not yet returned the sums of money or any other property obtained through the offense or found that the equivalent, to persons prosecuted for sexual violence. How the bail is refunded.
Sir, you have 2 more minutes. You have 2 more minutes.
Okay, thank you.
Yeah.
I want to share with the role of prison center in protecting the human rights. We have the regime article 61 of law saying that any prison official and surveillance agent guilty of act of torture, cruel treatment, punishment of the Legal Act must be subject to disciplinary and criminal proceedings. So in Burundi, you have centers for minors in conflict with law. These centers make sure that all children are assisted by a lawyer, and all children under 18 are no longer admitted to prisons with adults. All children has the right for vocational training in centers. So we have challenges in prison. We have challenges related to the food, healthcare challenge, accommodation conditions, absence of separation between men and women in places of detention. But we have a plenty of opportunity to meet. And challenging when some women are arrested by officials who are not the same sex. And I want to present you the practical insights for tackling the defined challenges. In the event of an arrest, woman must be searched by the person of the same sex whenever possible. The practical way to increase or recruit more police women to grant the woman the right in police prison by making sure that she is guarded and supervised by the staff of the same sex. This can also help to ensure that no male official shall enter the woman's section without being accompanied by a female member of the staff. Appoint or hire more doctors in charge of prison. Sign contract with the hospital that receives sick prisoners, including the psychiatric treatment centers. Due to the high numbers of prisoners and the reception infrastructures which are old, effort must be made to build prison cells or rooms to meet international standards in terms of the respect of human rights, including the respect of the right to dignity and hygiene. Conclusion. Burundi's criminal procedure registration under prison law constitution has a significant impact on human rights and the international standards relating to procedural safeguard for arrested and detained persons. Burundi must make effort to continue to comply with international law in terms of normative content and implementation mechanisms by making legal analysis and considering some challenges for arrested individuals. Thank you.
Thank you. Thank you very much. We apologize for the technical hitches. Yes, you've taken us through the legal framework in Burundi, rights of criminal suspects, rights of pretrial detainees, and the different laws that apply different categories of offenders. I think maybe during the question and answer session, maybe you could tell us a little bit more about whether these measures are successful in keeping down the population of pretrial detainees in Burundi, and if they're not totally successful, what are the challenges and how do you plan to address them? But thank you very much. We'll now move on to the third paper, Effective Mechanisms for Management of Pretrial Detention in Sub-Saharan Africa, by Francis Enobere, Controller, Nigerian Correctional Services, retired. You have 10 minutes, sir.
Thank you very much, Chair. Distinguished participants, permit me to form up this distinguished that we are going to fly on a supersonic jet for very obvious reason. That's what I want to discuss. And the aim we all know that is to develop acceptable and sustainable strategies for managing pretrial detention. The objectives are there on the screen. Well, for the scope, I am going to draw inferences from 4 sub-Saharan African countries for comparative analysis, and the countries are Nigeria, the Democratic Republic of Congo, Kenya, and South Africa. For introduction, let me not bore this audience with the nitty-gritties of pretrial detention because we all know, except that it's being arbitrarily used and sometimes abusively applied. And that has drawn a lot of concerns from both local and international organizations. Particularly because there appear not to be effective mechanisms to regulate the use of pretrial detention in many jurisdictions. And processes are not equally in place to ensure expeditious trial of suspects in incarceration, thus having accused persons spending far more than what they would have spent in awaiting trial if their cases were tried. Let's look at some issues surrounding the reason why people spend long time. We have a couple of them, but we'll just pick one or two. Number one, we acknowledge knowledge gap and inadequate equipment to carry out timely and thorough investigation and prosecution processes. This, of course, can lead to unnecessary adjournments. And, of course, shortage of manpower. This affects both the prosecutor and the judges. And I think we heard some other speakers talk about that. We have also recognized, and this is very strategic, that the preponderance of people behind bars are there for facing capital offenses. We have had situations in Nigeria where some chief judges who enthusiastically want to go to a prison facility to go and decongest. At the end of the day, they go there in a facility where you have close to 1,500 awaiting persons. At the end of the day, not more than 4 or 5 will be qualified for such jail delivery. So the problem still remains, and we keep running around, on fire. These are other reasons why people are still long in prison. We have also identified inadequate logistics. Of course, in many jurisdictions, this appears to be a point of concern. Nigeria situation, for instance, in 2017 had a total of 70,000 plus inmates, out of which 67% are waiting trial. Yet not more than 25% of court duty vehicles were serviceable. This is what we had in the past. You can see some of those people that are pushing that truck to go to court are the inmates to be taken to court for trial. But luckily, look at where we are today. I think the system is responding. We also have inadequate resources. We have recognized this. Inadequate mobilization of technology. Knowledge gap in the use of ICT for data management and all of that. I think the man that handled AI says something about it. Of course, we cannot isolate the factor of poverty because not many of these inmates can afford quality legal representation. Let us look at some of the implications because these are the areas of concern. We have recognized overcrowding and, of course, with the attendant health challenges resulting from poor ventilation, inadequate water, potable water, compromised feeding system, bullying, and other forms of human rights violation associated with overcrowding. Well, these are all other problems that can be associated with overcrowding. They are well conversant with them. It can impact the psychology of the personnel, which they can transfer the anger on the inmates, you know, through torture and other forms of human rights abuses. There's no gainsaying that overcrowding impacts the fiscal infrastructure. It also compromises all other processes put in place for adequate reformation and rehabilitation of offenders, because when you have a mixed bag, it becomes difficult to isolate them. Then this is one area that is of concern to me, and I want it to be of concern to everyone here. The security breaches. Now, pretrial detention, that is abusive use of pretrial detention, has been linked to external attacks on custodial centers. In almost all the cases we have experienced in Nigeria, we discovered that the attackers, after busting the wall of the custodial center, they go straight to cells that are containing awaiting trial inmates. They break them open and literally leave the ones containing convicted inmates. So, and this is what we have been, noticing. So that there's a strong link between abusive use of pretrial detention and the armed attack on custodial center. Although this has not been reported so much in so many other sub-Saharan Africa countries, but the possibility of the menace spreading cannot be overruled. Now, let us look at some disturbances we've had in the past on custodial centers. Look at that one where because of the quality of the picture is not coming out well. I marked that separately because it wasn't, though it's an external attack. Okay, I think that's the NSAS. NSAS, when they broke into our facilities, both awaiting trial and convicts were all released. The same thing that happened in Owerri. They released both awaiting trial and convict. But specifically, the one that happened in Kaba in 2001, another one happened in Abolongo in 2001, another one in 2001 in Jos, and then of course the recent one everybody is that's making the news over the place is the one that happened in Kuje. They were all perpetrated by external attackers that came purposely to release those that are on awaiting trial. Now, look at some disturbances in the Democratic Republic of Congo. Look at, in 2017, 55 inmates escaped. In 2021, 1,300 disappeared. In August 2022, 800 vanished. So, and these people are being released into the public, into the society, to further compromise the security of the system. Now, look at Kenya experience. Now, look at, sorry, I go back. Oh, can I go back? Well, if it's not going back, no, it's essential, please. It's important, good. Now, what I want us to share in Kenya experience, what I want us to see in Kenya experience is that look at the number, almost negligible number of people that escaped. Look at, in 2001, just 14. 2001, yes, July, another 8. 2001, 19. 2019, 6. What we should understand is that so long as you have people in incarceration, there's always that tendency to escape. But what we are bothered about is the magnitude. Now, look at the experience in South Africa. In South Africa, between 2001 and 2002, only 21 escapees recorded and 12 recaptured. Now, this is what I want you to also see. Now, comparatively, you discover, look at Nigeria. Look at the percentage of those awaiting trial, 70%. Look at Kenya. Look at the figure awaiting trial, 42.7. DRC, 75. South Africa, 32. Now, can you draw nexus now between high number of awaiting trial persons and violent attack on custodial facilities? Because in Congo, you discover that so many, in their hundreds, they were escaping, just as in Nigeria, because we share almost the same number, the same percentage in terms of people awaiting trial. And that's what I said, Nigeria and the DRC, with high number of pre-trial detainees, appear to suffer more from external attacks. Well, in the countries that were studied, we discovered that overcrowding is associated with pretrial detention and human rights violation. There is knowledge gap in investigation and prosecution process, leading to delay in trial process. They all suffer poor funding and the allegations of corruption and indiscriminate arrest, reported in all. And of course, they all suffer logistics challenge. Then in conclusion, what I conclude is that pre-trial detention should not be abusively used because of the far-reaching implications, security implications. Yes, that's all my conclusion. Then there are a couple of recommendations there that we just pick one or two, that media and civil society groups should be interested in telling the public the far-reaching implication of pre-trial detention, because we want everybody to come to the pool to manage the menace. They say in my place, whether a man is tying a wrapper around his waist or his waist around the wrapper, the overall this is to protect the nakedness of the waist. Then I also recognize that capacity building in investigation and prosecution procedure is strategic. Capacity building. We have recognized knowledge gap. And I like what Prof. Diche said, that 40 years ago, she started hearing about this management of pretrial detention, the congestion of prison. 40 years after, it's the same story. We are still moving around the bonfire. See, no matter the number of times a man does acrobatic, the buttocks will remain behind. We need, if you, thank you. Please, what I'm trying to say is that until we consciously address the overaching problem, we will still be running around the bonfire and the problem will still be there. Then the practice, I think somebody spoke about this, practice of holding charge should be abolished. I agree with the person. And then we just take the other one and said increase in personnel. We need to increase personnel. We need to train them. So increase the number and train them very well. You don't slap a native doctor with bare hands.
Thank you very much.
So you need to
thank you very much.
And then that is it.
One more proverb.
Thank you very much, Prof. Thank you, distinguished audience. You see, unfortunately, I don't really intend to make it comical because it's a very serious problem.
This is true.
It's a very serious problem. I believe that reform is possible. My prayer is that may our collective effort not be. I leave this distinguished audience with this quotation from Henry Ford. And he said, if you think you can, right? If you think you can't, but right both ways. Success is the decision you make. I thank you very much for listening.
Thank you very much. I found that a very interesting paper. The presenter made a comparative analysis between 4 jurisdictions and drew a very interesting nexus between overcrowding in prisons and abusive use of pretrial detention with external attacks that are made to free those people from detention. I actually haven't come across that argument before, and I found it very interesting. He rounded up with some very pertinent recommendations, especially regarding the need to increase our capacity in investigative and prosecution procedures. On the issue of the holden charge, maybe somebody from the audience can address that, but I believe that actually has been abolished by ACJA. So whether it's being observed, whether that prohibition is being observed in the courts is a different matter. Thank you very much. Okay, so we'll move on to the next paper, which is the impact of Force Order 20 and visits to detention facilities by chief magistrates under ACJA 2015 by Simon Lowe, SAN.
Thank you, moderator, and thank you, the audience. I think the controller of prison has made my work very easy by giving all the percentages, the analysis, and the implications of retail detention. It is even one of the issues that even prompted the promulgation of the Enforced Order 20. By way of introduction, the Nigerian Police Force, like many other institutions of government, is a creation of the Constitution. So the 1960 Constitution, 1963, 1979, and the present one, 1999, all make provision for the creation of the Nigerian Police Force. And the Constitution also made provision for the duties, functions, and powers of the police, as well as empower the National Assembly to make law that also include further powers that are vested on the police. It is in view of that the Police Act 2020 was promulgated by the National Assembly. And Section 4 of the Act made provisions providing for the powers of the police, amongst others, is to prevent and detect crimes, protect the rights and freedom of every person in Nigeria, and provide, as provided in the Constitution, the African Charter on Human and People's Rights, and any other law. Maintain law and order, public safety, also protect life and property of all persons in Nigeria. Enforce all laws and regulations within and outside Nigeria. And this issue of enforcing all laws has been a bone of controversy in Nigeria with the other agencies, where, like the civil defense, lay claims to have monopoly of enforcement of laws relating to vandalization of pipelines. Similarly, the NDL also lay claims to having the main power to prosecute or investigate cases involving drug offenses. But all these things were settled by the Court of Appeal decisions in the cases of RGP versus Andrew, which is in 2014, where the Court of Appeal, Ikiti Division, held that the police can prosecute cases involving drug offenses. Similarly, the recent decision of Federal Republic of Nigeria versus Abu Daniel, also settled that issue of vandalization. So the police are charged with all these responsibilities. So the most important functions or role of the police for the purpose of this paper is Section 64 to 69, which deals with the detention of suspects in police stations and report of police to supervising magistrates, as well as Section 70 of the Act, which deal with chief magistrate visit to police station every month. Section 69 of the Act and Section 33 of the Administration of Criminal Justice Act are in pari materia. Pari materia in the sense that they all make similar provisions. An officer in charge of a police station or an officer in charge of an agency authorized to make arrests shall, on the last working day of the month, report to the nearest magistrate the cases of all suspects arrested without warrant within the limit of their respective session. This has been a very thorny issue. Whether that have been complied with has been another issue. The report shall contain the particulars of the suspect arrested as prescribed in Section 44 of the Act. The magistrate also has the duty on the receipt of such report to forward same to the Criminal Justice Monitoring Committee, which shall analyze the report and advise the Attorney General of the Federation as to the trend of arrests, paid, and related matters. The Act also imposed on the AG, that is the duty upon receipt of the report, to forward them to the National Human Rights Commission, Legal Aid of Nigeria, or a non-governmental organization, make the report available to them for their necessary action. Similarly, Section 70 of the Police Act and Section 34 of the Administration of Criminal Justice Act also have similar provisions, which is to the effect that the chief magistrate, or where there is no chief magistrate within the police division, any magistrate within the police division, any magistrate designated by the chief judge for that purpose shall at least every month conduct an inspection of station or other places of detention within the territorial jurisdiction of the place where he is presiding. And during that visit, the magistrate may call for and inspect the record of arrest, direct the arraignment of a suspect, and where possible, grant bail. Also, an officer in charge of a police station or an officer in charge of an agency authorized to make arrests shall make available to the visiting magistrate or designated magistrate exercising its powers under Section 1, Subsection 1. This issue was recently raised where it was alleged that a magistrate went to inspect a police cell in Lagos, and he was challenged. Even though it was widely reported that the said magistrate was harassed, but the command commissioner of police, that is Lagos State Commissioner of Police then, was quick to refute that. And the magistrate also came out to refute that such a thing never existed. So it was in view of all these issues that this First Order 20 was promulgated. And First Order 20 was promulgated to ensure that detainees in police custody have access to legal services, free legal services. That is why the aims of the First Order 20 are provided in the paper. One is to foster community policing and strengthen services delivery by the police. Two, increase protection and promotion of the legal and human rights of suspects and detainees. Three, improve accountability. One of the issues that we have been having that is that pretrial detainees are crowded in so many police stations is lack of accountability. And this duty Order 20, which imposes on police station accountability to the magistrate and from the magistrate to the Attorney General, making mandatory for police officers in charge of police station to report. So it is a vital tool to ensure that detainees are provided with the necessary legal services to ensure that their rights are protected. The legality of
you need to round up. We're running out of time.
Very well, very well. The legality of the First Order 20 recognizes police duty solicitor scheme, and the scheme is also recognized by Section 35, which make provision for access to legal services. So, what are the challenges of the scheme? That is the police duty solicitor scheme. One of the challenges is movement of personnel. The parties that are involved, that is the stakeholders that are involved in the scheme, are the police, the legal aid, and Open Justice Society initiative. So when there are movement of either police officer from one police station to another, it becomes a problem because those who came in may not have that knowledge to implement the scheme. And the same thing with the legal aid as well as the Civil Society Justice Initiative. And secondly, there is lack of manpower also. There are not enough legal officers from the legal aid and even the civil society initiative to properly enforce or implement the system. And then lack of funds and infrastructures. Most of the states that were choosing as pilot state were unable to effectively utilize and implement the scheme because they were having lack of funds and then infrastructure by way of office accommodation where those lawyers can then stay and then render their services. Recommendation. In the recommendation, we will recommend that there should be serious awareness. That is, there should be public enlightenment. Public enlightenment in the sense that most people are not even aware that these services existed in all police stations. So participation and taking advantage of most of these services is not there. So creating awareness by way of propagating them on televisions and other jingles or even the newspaper is very important. And then secondly, we recommend that the scheme should be properly funded.
Okay, sir, I have to ask you to round up at this point.
And then lastly, there should be constant sensitization of both the public and the police officers and training of all that are involved in the implementation of the scheme. Thank you.
Thank you very much. We do still have 4 more papers, which is why I was anxious for you to round up. There's one that's not listed that's going to be delivered virtually. So do forgive me if I interrupted you, but it's very necessary so that we can move forward. I think this last speaker has begun to address the issue of detention in police facilities. All along, we've been talking about pre-trial detention in the prison system, and we're now talking about detention in police facilities before the suspects are even charged. And continuing with that theme, I will now ask Mr. Bayo Akinlade, the convener of the Duty Solicitors Network, to talk about visiting detention facilities by magistrates. What have we achieved?
Thank you very much, Madam Chair. I want to thank the Learned Silk for going into the issue of the PDSF scheme. But one thing that we've had a problem with that scheme for the last 4 years is that the police always claims that they don't know anything about the PDSF scheme. So perhaps maybe Leonard SAN could speak to the IG and let him know that all police formations are to respect Force Order 20 in that regard. My paper is going to be I want to be very brief about it. So let us look at these things practically speaking. Every time a police arrests somebody, the question I ask is, after 24 hours, what's different between that arrest and detention from kidnapping or abduction? Really, frankly speaking, why? Because after 24 hours, the next thing the police is asking for is sureties and bail money. So basically, we are not different from a kidnapper or somebody who has abducted somebody. So it's very important that we start effective dealing effectively with the police and how they arrest and detain people. We're not chickens, we're human beings. Now, the other question is, how does this affect the psyche of the person detained, especially if... And that also goes to the Nigerian prisons too, because Nigerian correctional services are one of the worst violators of human rights. Once the person gets into correction, powers that be. So how should law remedy this, and how justice is seen to be done? Now, the interesting thing about ACJA is that it seeks to address many of these issues, but like ACJA, like many other laws. It's just something on paper, and people really have no intention to fulfill or to apply these laws. So here I just said the priorities of ACJL. You can always see that in, I use ACJA and ACJL interchangeably. The principal law, of course, is Section 33, and we've all discussed that, and Section 34. Now, this is how I put it. Section 33 and Section 34 is like if Muhammad doesn't go to the mountain, mountain should come to Muhammad scenario. Because Section 34, I don't think is ever implemented. Now, somebody can correct me, but no policeman gives a record of anything and sends it to the magistrate in charge. They don't do that at all. Now, Section 34 comes in, which is a very fantastic innovation, and it's a visit by magistrates. And it says all the things that the magistrates can do during that visit. Again, another wonderful legislation, but the practicability of I don't think they actually even looked at how that was going to be played out. Now, even these visits, what's happening on ground is that the officers in charge, DPO or the area commander, are very antagonistic towards the magistrate in this visit. Now, in some police stations, they are very nice and they're very kind, depending on their level. And in some other police stations, when the officer in charge has done something illegal, maybe arrested somebody or is detained somebody that is of high financial value, you find that once a magistrate comes into that scenario, they start acting out. Okay, so basically these are what we're looking at. I guess somebody changed my fonts on this thing because this is not what it looks like. Now, again, what's happening? You have a situation where it also mandates a judge to visit federal detention facilities, federal law enforcement detention facilities, but this is also not happening. So I think maybe the conveners of this conference can also look at this. Why are judges not visiting EFCC detention facilities? Now in Lagos, we have a very brave magistrate who actually goes to the EFCC detention facilities in Ikoyi. But what's happening with NDLA? What's happening with customs? What's happening with immigration? No judge is ready to go into the detention facilities to do anything. Why is that again? A lot of questions we're asking here. Now, what happens when the police refuses to cooperate? There's a section for sanctions. Nothing is happening. No sanctions. Especially the 3 cases we have in Lagos, respectfully, Leonard Seal. Those things happened. The police can deny all they want, just the same way they deny they are not on the streets collecting bribe. The same way they denied that they didn't harass a magistrate. Now, what are the sanctions? It's clearly written there. But interestingly, like every law, the police is above the law. Everybody else is under it. Now, nothing is happening in that regard. Even the sanctions are insufficient. A policeman interferes with the work of a magistrate. Some people can't even begin to conceptualize a disobedient policeman. And it only says that the misconduct will be treated according to relevant police law. What does that mean? Nothing happens to that policeman. And I've suggested that the policeman should be arrested immediately. To arrest. Should be arrested immediately and be detained for 24 hours and then be arraigned immediately in another magistrate court for violating this section. So that's what I'm recommending there immediately. Now, let's look at even the ACJMC. Another problem. Look at the constitution of the ACJMC. Now, this is the ACJMC that is supposed to monitor and they're supposed to send all the reports to, and they're supposed to make all the recommendations and make things better. Look at who is the head, the chairman of the ACJMC. The CJ. Where would the CJ have time to sit down in a committee and start reading reports from the police station? It's like some of these things, provisions were just set not to work. You know, it's just self-destructive. The AG, the judge of the Federal High Court, the same judges that don't even go on the visitation. So look at it, the IGP or a rep not below the rank of a CP is supposed to be a member, controller of prisons, of correctional facilities. Everybody in this composition, there are people who are completely ineffective because of their original portfolios. They cannot be effective for something like this. So it's another thing we should look at. We should completely review the membership of this committee.
2 minutes, Bio.
What have we achieved? The Duty Solicitors Network decided that, okay, this law is not even made to work. So what we did was, PDSS says that volunteer lawyers should go into the police detention facilities to provide pro bono services. So if that is going on, why can't we support the magistrates to start this thing? So in Lagos, what we practically started from in Lagos was, we approached the chief judge and said, look, we know you don't have the resources to do this, but we as volunteer lawyers, Bar Association, will accompany magistrates and provide all the logistic support to encourage magistrates to go on this visit. Now, from what has been happening, you would see that the magistrates actually need us lawyers to accompany them because of the harassment they receive when they get to the police station. And many magistrates don't even want to do it because they are disrespected when they get there. They are lied to, and their job basically is so difficult anyway because they have to sit and at the same time they have to go on this visit. So we came together with the idea of having magistrates being supported by pro bono lawyers from the MBA. And I can tell you now that the program has worked enormously. We've gotten support and funding from people like our chairman here of session, people like Professor has supported. And I don't have the figures here, but our team in Abuja, for instance, they go almost every week now and support the magistrates in these visits. What are common constraints? Funding, logistics. The magistrates' workload is also a very difficult thing to balance. They have all this work. Magistrates in Lagos have up to 400 cases in their docket, and then you expect them to start going from police station to police station. The average time it takes them is about 4 hours just visit to police stations. So we really need to look into those things. Now, reporting also, we need to streamline our reporting system. Personal interest and motivation of visiting magistrates, like I said, a few of them don't even want to do that. So we've already talked about logistics, magistrates' workload. They can optimize their way of directing their cases and so that they can do the court thing and they can still go to the police station. Of course, partnership is always the way to go. The National Human Rights Commission has an act that allows them to go into detention facilities. Legal Aid Council also has those powers in their act. So we just come together with the DPP's office, OPD, everybody comes together, FIDA, MBA, everybody can come together and support this thing. What are the successes? Of course, there's a decline in indiscriminate arrest. The police knows that the magistrates are coming.
Is this your last slide?
Yes.
Okay.
So we've had several successes and they are outlined there. Basically, there's more respect for human rights. Now, of course, the challenges again is maintaining surprise so that police doesn't know that we're coming. The police has a tendency to hide suspects. Lack of cooperation from police is a big problem. And of course, caseload of the magistrates. Solutions is that we have to just look at the entire law again and start thinking out of the box, use innovative ways to combat these problems. So thank you very much.
Thank you very much. So the last speaker has told us some of the practical problems with implementing the good intentions behind the actual provision on magistrates' visits. And he's pointed out that while visits of police facilities are actually taking place, the other law enforcement agencies such as NDLEA, Customs and Immigration.
Which is a very real problem, trying to intimidate magistrates, and there are no consequences when they fail to cooperate. Then went on to list all the challenges and the constraints and made some recommendations as to how to improve the operation of what is actually a very laudable provision in theory, but still needs some tweaking in practice. So we now move on to the next paper, which will be delivered by Funke Adeoye, and who is the founder of Hope Behind Bars Africa. And she's going to be talking about leveraging technology as a tool for reducing pretrial detention in Africa, lessons from Kenya.
All right. Yes. Good afternoon, everyone. All protocols duly observed. I will be speaking on technology as a leading trial detention in Africa. And so a whole lot has been said already. A whole lot has been said already on some of the things I would be discussing, and in the spirit of time, I would just try to summarize my presentation. So the presentation is actually a summary of a 6,500 paper. In terms of the scope of pretrial detention, I'm looking at not just pretrial detention at the police, at the prisons, but the police. Yes. Yeah, so those undergoing investigation that are being interrogated by an investigating agency. Okay, so they are waiting trial persons who are currently in prison and those that are currently undergoing trial but have not been sentenced. In terms of pretrial detention trends and data in Africa, a whole lot has been said to, but just to mention that currently in the world, Nigeria is the 20 countries in the world that has higher pretrial detention. Professor Isabella, while she was speaking, said 40 years ago we were discussing this, and it's quite profound. As far back as 2012, I had final year thesis, justice, and at the time, Nigeria had about 65% of persons awaiting trial, and as at today, it's about 73%. Show how much of reform. Okay, so the framework on the use of pretrial detention that ideally everyone who has been charged is proven guilty, and even though there are reasons why pretrial detention, the framework actually provides that as much as possible, those who are arrested are presumed innocent until proven guilty. So a little bit about the drawbacks on the use of pretrial detention. A whole lot has been said already. The issue of overcrowding. It was beautiful. It was interesting to hear what the controller of prison had to say concerning pretrial detention and how it impacts on security. There is also the fact that being in prison affects the ability to prepare a defense, and that it also affects family life, right? Disrupts family and private life and the ability to work and earn a living, especially when he or she has not been sentenced or he or she has not been adjudged to be guilty. So why is there an overuse of pretrial detention? A whole lot has also been said about this. The fact that we have restrictive laws that promote pretrial detention. We have police and prosecutorial influence. We have corruption. We have a lack of coordination between criminal justice agencies, prolonged judicial process due to lack of automation and all of that. Now, so this would bring me to my conversation on technology, the place of technology. You'd say here that
What I will be saying about technology today does not presume the fact that technology is the only answer, is the only panacea for using pretrial detention in Africa. And also to say that technology here is looking at the complementary efforts of the role, the complementary efforts of automation, yes, in speeding the justice process or in ensuring that the justice process it goes on faster than it is. Also, I think it was in the first session that the lecturer mentioned smart automation, AI, artificial intelligence. So I did not talk about artificial intelligence in this paper because there's a whole lot of discussion around the human rights implication of same, and I felt like it's something that we needed a whole paper to talk on, and it was beautiful that someone had spoken about that. Yeah, so the place of case management technology in the place of the police. Now, currently in Nigeria, when people are arrested, when they have to take statements manually, when there is really no digitalization in our police at the stage of the police. Someone earlier had also spoken about investigation and the use of electronic tags or tags to actually monitor who have been arrested, to prevent them from running away. So that's one of the foremost places that case management technology and technology can actually come into place in helping to reduce pretrial detention. There is also the place of case management technology at the level of the judiciary. Now, this is actually coined from the Kenya practice directions on use of technology for their cases. So what would happen? I think it was earlier in the morning someone mentioned that he had a case and he went to court and found out that the case wasn't going to hold. This is a very good place for technology to come in, by just logging onto a website or logging onto a management system. You can find if a case will be coming up, you can find more details about what will be happening of the cases and what have you. And it's to say that even our courts have actually given a go-ahead with the use of this technology. We'll get to that shortly. Verification and identity management technologies. So sometime in 2017, I had handled a case of someone arrested. It was a case of mistaken identity, spending about 3 years awaiting trial. And after, so in the 3 years he spent awaiting trial, his file was missing. So for 3 years, he did not go to court. He was just there stuck in the prison in Umahia for about 3 years. Now, this is one area that identity management technologies can come in by helping to ensure that people are thoroughly verified at the point of arrest, and also ensuring helping to do a synergy between the technology that the justice system can have and what we already have presently. We already have so many technologies in terms of in Nigeria, the BVN, the NIMC, to do a synergy between these technologies. Automation hearings has been said about this today. At Kenya, for instance, last year when COVID-19 happened and the courts had to shut down, Kenya was one of the countries that was out there in terms of providing virtual court hearings. Now, we know that not all court hearings are virtual, maybe like trials, but there is actually maybe motion hearings and the likes to if infrastructure for this. Can you hear me? Electronic monitoring of cases. Yeah, I think this is also where technology can come in. Last year, a whole lot has been said about Lagos. Gavel and the state government actually launched this Justice Clock, which is basically a web application that helps to monitor cases, monitor how fast a case is being handled, to monitor the number of cases that go into trial and how long it takes. So web applications can be used to help monitor cases.
Yeah, so web applications or various forms of technology can actually be used to help monitor cases and to also just create some form of accountability. Because when you go online and you check Justice Clock, you would actually see how fast certain cases are going on and the cases that need to be sped up. The illegal aid. So I don't know if illegal aid is the word here, but then in recent times, we find that in addition to going to prison or going to the police to find people who are in need of legal aid, you can also you can also find people who need legal aid online. So like my organization, for instance, and a couple of other organizations I know, people just reach out to us on social media that we have this person that has been awaiting trial for several years or for some months and he or she needs legal aid and they're able to access legal aid. That way, it helps to reduce the time that it will take for some legal practitioner to go to the prison to interview them. Just by reaching out to organizations that carry out legal aid, you can give them access to legal representation. Then the correctional database system, which I know there's some work already ongoing on this in Kuje and Nulai. I know Nulai has been working on something like this, which is just perfect. Would create a system where the people who are in prison will have their names listed, and it's going to be like a national database that everyone can access and know who is in need of legal representation and whatnot. You would also know who has been in prison for a very, very long time. So what are the factors that hinder broad adoption of technology in criminal justice process? So for instance, the idea of video conferencing that is being used in Kenya, we have issues of limited, where being in prison alone is really, really tasking. So limiting court hearings to virtual sessions alone can actually affect the psyche of the incarcerated person, because so for some of them, that's going out of prison to court is really what gives them access to the outside world. So that's one of the factors. The issue of secure internet connectivity, I mean, we've had some virtual sessions here today and we could see the impact of using of internet, yes, the internet connectivity in the country. So that's another challenge. The other challenge would be the place of capacity, the need for capacity building training of all judicial officers and everyone who is involved in the judicial service provision. There is also potential threats from cyber attacks, the fact that we also have privacy and data issues. The high cost of technology is another one, not just the high cost of technology, the cost of maintaining technology. And also that we also need specialized hands to actually get this technology running for as long as possible. And of course, the elephant in the room, which is electricity in this part of the world. So imagine if, a virtual session is going on and they take the lights at the prison and, it will just disrupt court processes. So that leads me to my recommendation, which is basically need for capacity building training on what we can do, how we can actually help foster justice delivery using technology across board. The need for the judiciary to look to the broader scope of data protection, security of systems, digital literacy, which is really key, and also the need for synergy, because again, all of these will not be achieved by just the judiciary or the police alone. The need for CSOs to begin to come up with innovative ideas that would help implement technology and help implement collaboration, basically. Thank you.
Thank you very much. I think the last speaker has very succinctly taken us through the various technological solutions that could be used for reducing pretrial detention, and she's also pointed out the challenges with doing that. Personally, I tend to think to solve the larger issue of electricity. Some of these things are nice to hear about, but are probably not within reach at the moment without significant funding for maybe alternative energy sources for the courts. I was especially intrigued by the e-legal aid suggestion. That's very interesting. But let's move on to the second to the last paper, which is going to be delivered by Clement Okech,
who is going to talk about improving sentencing decisions through offender assessment, current practices in probation, present tense inquiries, and evolving practices in Kenya.
Thank you so much, moderator. I know perhaps I'm one of those who are between you lunch, and I don't want to be taken captive and taken to prison because of your violation of your rights to food. But then nevertheless, I have a paper to deliver which is very long. It's about 14 slides, and I'm wondering whether a full paper and a bridge paper in the slides and myself who should speak to these issues given the time available.
Can't you summarize?
Yes, that's exactly what I'm going to do.
Yes.
Because I think it will be nice to leave you with the papers, but because I'm here, I can speak off the cuff on the issues that are in those papers and slides and see whether I can communicate better than what would be in the slides. Sometimes slides confuse. You don't know whether to listen to me or to read what is up there. So I choose to summarize the 6 key areas that my paper has been able to delve with within the 10 minutes available. Thank you.
Fantastic. Thank you.
Now, in terms of context, I think a lot have been said about the African situation in terms of criminal justice delivery. And that context speaks to overcrowding. Why? Why is there overcrowding? I think that's the issue that we have been delving here with. And that issue is about the thinking of whether it is because of the size of the prison that makes the facilities congested, or whether it's the decision to congest them. In other words, decision to incarcerate. Which is which? We have fewer prisons, smaller wards, or it's because we indiscriminately decide that somebody has to go into incarceration. Which is which? And that's the problem we are having, particularly here in Africa. There is also the issue of risk, that we perceive risk to be the main reason why people have to be incarcerated, because we think of dangerous people being out there, and the only square place they need to be is in prison. Is that the case? How do you know that that person is a risk person? What is risk in this context? Risk is not necessarily dangerousness. If you are able to measure dangerousness, then we'll be able to deal with the risk that is perceived by the sentencers, the magistrates and the judicial officers, or by the public. But that is not the case. Risk is a probability of an event occurring. But the intensity and the harm with it that may come with it is what we may be able to think about as to if we can isolate that, and that is where now my paper will be talking a bit about that. Now, we also understand that sentencing and punishment has been debated over the years, and we hear about retribution being retrogressive. If we all understand that retribution is retrogressive, then why are we still perpetuating it in the 21st century? Why are we not taking forward the other utilitarian reasoning for crime reduction, which is deterrence, especially deterring the individual offender? Why are we not talking about rehabilitation and reformation? And why are we not talking about reduction of crime? Indeed, all the agencies working in the justice system are having one common agenda. And the common agenda for the judiciary, police, prisons or corrections, probation, is to prevent crime. And yet all these agencies work against each other. They compete against each other. They work in silos. And that is the problem that we must try and deal with. And the indecisiveness in that perhaps can be addressed if you look at the issues within the individual culprit that they pass around themselves, so that becomes easier to make decisions for that matter. The utilitarian concept of punishment allows for positive way of looking at rehabilitation, looking at the strength factors in this person, looking at the positive image and the what we call positive risk factors that, if addressed, would be able to limit the risk that the magistrates or judges might think were pushing these people into criminality. Now, in Kenya, we have had probation system, and in probation system, Kenya is very elaborate. Every court station has more than 10 probation officers. All of them are well trained. All of them from the university, trained in criminology, in social sciences, in various fields. And of course, being given additional training, professional training within the service. That means, therefore, that every court, if there are courts of, for example, about 10 magistrates, then almost each magistrate has a probation officer attached to that. The role of a probation officer in sentencing, therefore, enables the court at that level to transform itself a little bit into an inquisitorial system, trying to bring in the probation officer to find out the reasons behind this person committing crime, so that you move away from punishing the offense into moving into punishing the person, and not the offense that he has committed, but the reasons why this person continues to engage in crime must be brought beforehand when the sentencing is being passed. Now, the next thing which I want to say about the pre-sentence reports that probation officers provide to the magistrates. Tomorrow I'll speak more about how we go about that. But in this case, I only wanted to bring in the evidence-based approach in which we have been trying to invigorate or to improve on the pre-sentence reports that we have. Pre-sentence reports are made by probation officers, first of all, to formulate the theory behind this person committing crime, to understand the person's personality beyond the crime he has committed, to look for resources that will be able to enable you work with this person if he was to be granted permission to be serving their sentence in the community, or if he was to be incarcerated, then you look for the resources to address those issues while this person is incarcerated. Don't forget that incarceration in correctional facilities is a controlled environment. You'll not be as sure whether that person will change when they go out to the real world. And science has it that it is likely, somebody is likely to change when supervised in the community compared to when supervised in the correctional facility. They change better in the community because that's the real world. Now, the other thing which I want to speak about is that within this new system of what you call evidence-based system, we have principles underpinning them. And the principles being the risk principle, the need principle, and the responsivity principle. Those are key principles underpinning the work we do with the courts, and especially developing pre-sentence report and interviewing offenders. The risk principle looks at the past, the issues that would make you think that this person is likely to commit the offense. The need principle looks at the crimogenic needs, those factors which, if changed, would make this person better not commit crimes. The responsivity principle looks at how then do you work with this person if this person was to be given a chance to work with. So that means if the court was to be availed a report that is embedded in this principle, the court would not think about the retaliation. The court would think positively and look at ways of changing this person. Have it been identified, the issues, the drivers to criminality, have it been identified using the tools that we use at that level. And that means, therefore, that the reports that we write to court are consistent, are standardized, are scientific. You could be able, with certainty, say that the reasons that this person went to commit crime have been proven because a tool has been used to be able to generate that information that is given to court. Which brings me to the second last point, which I want to talk about, is that we have been able to develop scientific tools, of course, borrowing from the new world, that are able now to inform most of our pre-sentence reports. Half of the country in Kenya currently have been trained and use these assessment tools that are embedded in these principles that I've spoken about. And the result is that magistrates and judges who look at our reports generated using these tools are much more appreciative and are much more confident to use the reports that we have compared to the magistrates to the reports where we use only generic social work, clinical methods of eliciting information about this offender and the offense. And that means, therefore, that the tools that we are using, if used appropriately, would be able to inform sentencing so that the magistrate does not need to, for example, throw a dart so that it hits 2, you sentence that person to 2 years. because the discretionary nature, the way in which we dispense and we punish or we incarcerate people is discretionary. And yet, that discretion is exercised sometimes not judiciously, because what informs a judicial decision must be embedded in the Constitution, it must be legal, it must be well informed. And therefore, if the court has the Constitution and the law, which other social information does it have to make a better decision in terms of sentencing? We know law is an art, it's not a social science per se, as far as I know. Then how do you use abstract law to punish a human being who reasons, who feels? Then that means you must employ certain humanistic reasoning to be able to understand why this person commits the crime, so that you are able to equate the punishment this person deserves and the issues that are supposed to be addressed. And that's what in Kenya we are doing. We are looking at the positive side of a person and being able to provide this to court. And with these tools, we have been able now to build the confidence of the sentencers, that they are seeing that it is not an abstract positioning of ourselves, and because we're in court, we can be able to convince them, but they are seeing a scientific reasoning that makes us come to the conclusion or the recommendation that we are making to court using this pre-sentence report. In 2018, we caused an amendment to the Probation Offenders Act and brought in a clause that mandates the court to demand a probation officer's report, meaning the pre-sentence report, if they think of placing that person on probation. Why we did this is that we were trying to control arbitrary awarding persons probationary sentences without the involvement of the professional who is a probation officer. So we have seen a lot more improvement in that, and we have seen more magistrates now gaining confidence and giving us more offenders to be supervised in the community. Finally, is this application, can it be replicated in other countries? I think that's where what I may call my key recommendations. The fact is, if you are going to use the scientific method of using this assessment tool, you cannot replicate, you cannot transplant one to the other. You must be able to domesticate those tools. You must be able to make them culturally relevant, which means even though the general theory about these tools may be the same, but you must be able to come and see whether they can work for your situation. Otherwise, you'll be bringing a tool that will not be able to operate in this field. The tools that we have, which you have seen there, although they have been borrowed from, I think most of these things, scientific things, are manufactured. The innovation centers are in Canada. The factory is in America. The value addition center is in the UK. And the distribution centers are all over the world. But the fact is, each person must have their own tool that fits them. That's the point which I wanted to pass across. And thank you so much, ladies and gentlemen, for listening to me. Thank you.
Thank you very much. That was really interesting. I should have mentioned when introducing the speaker that he is the Executive Director of Probation and Aftercare Services in Kenya. I think that was very, very impressed to hear that there are 9 probation officers for every court, and that's the least number. Yeah, that's impressive. I think I've always wondered about the sentencing principles or policies that Nigerian courts use. You have cases where somebody who stole a tuber of yam gets 3 years in jail for stealing, and then somebody else who stole 6 billion naira from public coffers gets sentenced to 6 months, which is then served in a medical facility. We do need these scientific methodical diagnostic assessments that will aid our courts in their sentencing decisions to come out with rational and reasonable sentences that serve the primary purpose of trying to prevent crime and rehabilitate the offender. So that brings us to the last speaker on standby, organizers. Last speaker
Mr. Babatunde Akinonju, who is the founder of the Criminal Justice Advisory Group. He will be making a virtual presentation on effective mechanisms for management of pretrial detention in sub-Saharan Africa. Babatunde, you have 10 minutes. I should mention to you that your audience has not yet had lunch. So they will be very impatient if you exceed the 10 minutes allotment.
Right. I hope you can hear me, and I take on board on what you say about lunch. Please indicate if you can hear me. I cannot see myself.
Yes, we can. We can hear you loud and clear.
Right. Thank you. Okay. So I'll be speaking from perspective of England and Wales. That's where I practice. And I just wanted to commend the last speaker on the talk about pre-sentence reports, because that's very much a tool that is used in England and Wales. And actually, the other thing I should mention is sentencing guidelines, because of course I'm going to be talking about pretrial detention, but once you...
Recording in progress.
Okay, maybe he's back on. Okay, we lost you, but you're back. You're back.
All right, thank you very much. Yes, so I was just saying that the use of sentencing guidelines and pre-sentence reports are tools that are used in the English system, and the sentencing guidelines actually to remand a defendant in custody or on bail, because you're looking at the likely outcome. You know what would happen if the defendant is found guilty. Is a remand in custody then proportionate in that respect? And if one takes your example of someone who steals a tuber of yam, from the market, does that person need to be incarcerated pending trial? So I would just focus on, you don't have my presentation, but effective management of pretrial detention from England and Wales perspective. I will talk briefly about the structure of criminal courts, the courts and tribunal service, legislation and practice directions, criminal procedural rules. I think we've already spoken extensively about technology and, of course, funding costs. But just to start with the magistrates' courts. Now, the magistrates' courts deals with 95% of criminal cases in England and Wales. And I'm specifically England and Wales, not talking about Scotland or Northern Ireland. And most cases do actually end in the magistrates' courts. They have a jurisdiction of up to 12 months imprisonment now for some offenses. Most are between 3 and 6 months in terms of imprisonment. And of course, other sentencing options are open, fines, and what we call community sentences. And that's where probation plays a part. So there's exclusive jurisdiction for summary-only offenses, which cover major road traffic offenses, including driving with excess alcohol, minor public order offenses, and minor assaults, especially assaults where there has been no injury caused. The court is constituted of 3 lay justices who sit with the legal advisor. The legal advisor advises the justices on law and procedure. And in fact, I was a legal advisor in the magistrates' courts for about 25 years. You also have a district judge. The district judge is qualified, legally qualified. District judge tends to sit in the busy courts, like London, Birmingham, Leeds, and so forth. They can get through the workload quicker than the lay justices, and they also deal with complex cases as well. There's also the youth court. The youth court is part of the magistrates' court, and that is where they deal with offenders aged 10 to 17. And there's a special procedure for youth, even in terms of remands and sentencing. Then you have the Crown Court. The Crown Court is constituted by a judge, and for trials, you have a jury. So you have 12 jurors, and the jurors, the jury is the 12 persons are the ones who decide on guilt or innocence. The judge is there as, well, effectively the manager of the court, managing the trial process and dealing with pre-trial issues, including whether to grant bail or custody, and on legal submissions, and of course sentencing if the accused is found guilty. You also have recorders. Recorders are judges legally qualified, but they sit part-time. So you would have lawyers who are in practice, private practice, but they are trained to sit as judges part-time. And, they just assist in dealing with the workload. I know a previous speaker spoke about specialization. So even within the criminal justice system, you have judges who specialize, who are trained, so they have tickets to be able to sit on very serious offenses, such as murder trials or rape trials. And you have the prosecutors who also go through that training, because you would appreciate that in these trials, there is probably reliance on expert evidence, forensic evidence. There's the issue of witness care. There might be the issue of witness protection. So all this, you have the prosecutor, the judges, and even the defense counsel who receive special training on this issue. In fact, I run an online session under my criminal justice advisory group. And the last session I did was on effective prosecution of sexual offenses. And one of the speakers was the lady who has this training provided by the Crown Prosecution Service. And you actually have to be certified to be able to sit on serious rape, on rape trials. Now, administration. So we've talked about, for example, liaison between judges and defense, maybe judges and the police station, and how do you effect all that? And of course, all the issues about technology, liaison with probation, and so forth. There is the Her Majesty's Courts and Tribunal Service, HMCTS. The job of HMCTS, they're responsible for the administration of really all the courts, not just the criminal courts, the criminal, civil, family, and the tribunals service. So everybody, every person that works in the court, apart from the judges, are members of staff of HMCTS. And the role of HMCTS is to ensure that there is effective administration of justice. So, for example, when the last speaker from Kenya was, in fact, when I think it was Funke Adoye who was speaking about using video links from prison and so forth. We have that in England. It's the job of HMCTS to effect that. So, liaison with the prison to ensure that the prison appears, the prisoner remand appears at the right time. And there's the link between the prison and the court. There's a time for the prisoner to speak to his defense counsel, who would be in a room in the court. So have that private consultation before the case actually appears in court. And the advantage of having this video link is that it saves dramatically on costs. I can tell you the cost of bringing a remand prisoner, transporting that prisoner from the cells to a court is around about £500 per prisoner. And because, there's the need to comply with various human rights legislation and practice directions and so forth in terms of accommodating prisoners and so forth, and taking into account their specific needs. So it's not just bundling someone in truck. There has to be compliance with the law. Very costly, but that's the job of HMCTS to deal with issues like that. So the vision of HMCTS is to deliver a world-class justice system that works for everybody. And it is run by a chief executive, and there are various departments within that body, including human resources. HMCTS is responsible for the fabric of the courts, the court estates, ensuring that there are adequate facilities for all the court users. It's responsible for the technology. So HMCTS, there are 17,000 members of staff. And talking about technology, each person has access to a laptop because all the work is paperless. So all the information about someone in prison who is due to appear, what time, and so forth, that's all done electronically. And as has been said, there are the risks of cybercrime and so forth. That's all down to HMCTS. That takes
Babatunde, you have 2 minutes to round up.
2 minutes. All right. Let me just give you some statistics. So England and Wales population of roughly 60 million. The criminal courts deal with 1.5 million persons on average per year. The bill proportion of people billed by the police to appear at the magistrates' courts is about 13% of defendants. 9% are remanded by the police to appear at the court. They have to appear in court within 24 hours. Very strict guidelines. That time can be extended, but there has to be justification for it by law. 4% are remanded awaiting trial by magistrates, and 38% awaiting trial by the Crown Court. As of the end of December 2021, there were about roughly 13,000 defendants in custody awaiting trial. The legislation is similar to what other speakers have said across Africa. There are also custody time limits. There is also the criminal procedural rules that is very strict. But just my last point to make is about effective case management. And I think that has been emphasized by the other speakers as well. And just a quotation by a judge of the Court of Appeal, that time is not unlimited, and no one should assume that trials can take as long or use up as much time as either or both sides may wish to think or assert they need. Every trial which takes longer than it reasonably should is wasteful of limited resources. It results in delays to justice in cases still waiting to be tried. It adds to the tension and distress of victims and defendants, particularly those in custody awaiting trial, and for witnesses as well. So there's the onus on all players in the criminal justice system to ensure that there's no delay, and that only those who, as have been said, are at a risk, serious risk of harm to the public should be remanded in custody for the shortest time possible. So thank you very much for the opportunity to speak today.
Thank you very much. We've had the benefits of the perspective. We've been talking about sub-Saharan Africa all along, and we've now been given the benefits of
the perspective of what goes on in England and Wales. So that was the last paper in this session. I know everybody is hungry, wanting to go for lunch, so I'll limit the questions to 2 questions. Dr. Bello, the way your hand shut up, okay, let me call on you. Please do. Maybe I'll say 3 because you shouldn't really count. But go ahead.
Thank you very much, Ma. I just want to say that I was very excited when a brother from Kenya spoke about the probation services. And like I said earlier, these things have always been in our law. The use of probation, binding over others, and there's no ministry, there's no state in this Nigeria that does not have a ministry of social welfare services. Sometimes they are under the Ministry of Youth. They have employed probation officers, and many of them have never even been to court. So we have these things in our law. It's just to operationalize it. Get the states to know that we need to appoint probation officers, train them, give them the necessary resources, make them available in the courts. You know, we're supposed to be implementing child rights law. How will you implement child rights law without having a support, probation officers, social welfare officers who will do write the necessary reports to aid the work of the court? So I think we need to recommend that the state's attention should be drawn to this. We need to develop the probation services so that they can render something similar to what is going on.
It's the same old story that we don't lack for ideas, legislation. It's always the implementation where we fall short. So I'll take 2 more questions. The lady in the black hijab.
Yuma, I want to draw insights from the presentation of my brother from Kenya. But at the same time, I want to know whether most of your laws has this provision of may, or because in our own law, if the word shall is used, then there's no going back for sentencing. In fact, you cannot even enter allocutors, not to talk of maybe mitigating the sentencing. So if really most of your laws have may or, then I think it's laudable, and I think we can borrow that in Nigeria to review the provisions of our law, penal code and criminal code, to see those provisions that maybe probably we can change that word shall to or may, so that the judges will have that discretion of mitigating the sentencing.
One more question, and then I'll hand over to Mr. Okech to reply to that question. One more, this side of the room, nobody? Okay. The gentleman in the tie.
Thank you very much, Bennett Chair, for this opportunity. Just to mention a few things with respect to the state of things in the FCT, especially in the implementation of the oversight visitations. I wrote down a few points. Please let me just, pardon me to...
2 points only, please.
Okay, thank you very much. The first is that Section 33 reports in the FCT are being complied with. At the last record, we had about 71% compliance from police divisions in the FCT, so that is one. Second is that we have oversight visitations to places of detention, even by judges at the moment. That currently goes on. Have federal high court judges going on oversight visitation, places of detention. So just to make sure that, the update really about where we are at the moment. Surely we have come from a time when we were not having these visitations, but now we do have them going. I think it will be necessary to be aware that the visitations are currently ongoing.
Thank you. Thank you. All right, so I will ask Dr. Kesha to respond to a question that I raised in my comments after his paper.
The question was the difference between fine without trial and plea bargaining. So we have provisions that are different in the Rwandan Criminal Procedure Code, and the difference I can categorize the difference in 3 ways. One is that when we talk of fine without trial, in itself it means there is no trial. While in plea bargaining, there is a negotiation and the trial will go on. So that is the first difference. Two, the difference is that fine without trial only deals with fine, as the plea bargaining can deal with fine and other punishments. Then the third reason, difference I saw is that with fine without trial, the accused does not state that he or she has accepted having played a role in the accusation, in the accused crime. And it's not stating that I'm guilty. While in the plea bargaining, you are accepting that you are guilty and you reveal even more information about it. While in fine without trial, it does not necessarily mean that you have accepted you are guilty.
That's very interesting. I'll now call on Dr. Okech to respond to the question about.
Thank you so much. I think what I didn't mention is that even in Kenya, we have seen a proliferation of determinate sentences in our legislation, especially offenses related to sexual violation, forest conservation, alcohol beverages. We've seen those determinate sentences. However, the High Court has ruled that the legislator cannot tie the discretions of the court, especially in sentencing, given that sentences are supposed to speak to what is appropriate and not what is prescribed. And therefore, they have been able to open the lid in some of those determining serving murder cases, who were facing murder charges. They were convicted and were in the what you call death row. They petitioned the Supreme Court. And point number one. Point number two, so which means, and of course, our legislation, nobody in our country, nobody has been executed, although it's still in the penal code, since 1983. All those are commuted to life imprisonment. Manslaughter cases are given probation or any other offense that the court would think was appropriate at that particular circumstance, looking at the culpability and the mitigating factors of each case. Secondly, the Criminal Procedure Code under Section 216, the Kenyan Criminal Procedure Code under 216, and I think there must be a near similar provision here, demands of the sentencing court that they can call for evidence and information before passing a sentence or making an order. The key words there are before a sentence and order. And tomorrow I'll be able to elaborate more that probation is not a sentence as contemplated through that clause I've just mentioned. It is that clause, therefore, that as read with the Probation Offenders Act, that the court then calls for a probation officer's report, in this case, report, and in this case, a pre-sentence report. All offenses where there is a provision for a fine and a provision for imprisonment in default, of course, that brings in the discretionary powers of the court, and it cannot be a shall. And the majority of the penalties or the laws we have fall under that bracket. Very few, unless it is mandatory, determinate sentences like the ones I've mentioned, then we have a wide gap upon which to operate. Lastly, and tomorrow I'll also be speaking on this, who is in our prison? Who is there? There are people who are there because they just want. The chicken thief, must they be there? No. So which means we have very many people who we can remove out of prison and have them serve their sentences in the community without necessarily going through that process of incarceration. Finally, I want to speak about, who is the probation officer? The probation officer in Kenya is not a child welfare officer. I think that's the distinction I want to make. Like it is in England and Wales, so it is in Kenya. A probation officer is, in your language, a community corrections officer, a non-uniformed officer, a court officer, dealing with all criminal matters, be it perpetrated by a child or an adult aged 100 years. A probation officer, therefore, strides between the court and the community and is not restricted to corrections only. So we have two brought under our charge. And that means, therefore, that we are in between the court and the judge. With regard to cases that are a problem here in Nigeria, I hear our chair moderator said that we have good laws, but it's the implementation. Don't you have activist lawyers and organizations that can file PLC cases, that can sue government? That's the question.
Yes, we definitely have those. But all good things must come to an end, and I'm sure everybody here is starving. So I'd like to thank the panel for the very interesting and different African countries. Thank you very much.
Thank you so much, Mr. Chairman, for this wonderful session. Members of the panel, we sincerely thank you. Before you go down, we'll be having a group photograph on this stage. The faculty lead, Jury Trust Center, please kindly join them on the platform for a group photograph. Professor Adedeji Adekunle SAN. As we take the group photograph, may I sincerely thank the chairman of panel for today, our panelists for this wonderful presentation. May I also thank our audience for your patience, for your involvement, and for your concrete participation. We hope to have you tomorrow to this robust engagement. We sincerely appreciate you. So on behalf of Jury Trust Center, thank you very much, and we hope to have you again tomorrow. We apologize for keeping it for this long, and tomorrow we pray that we have a better session. Tomorrow's session commences 9 a.m. prompt. Please let us all come out early so that we can close early. Thank you very much.